Broadcasting. And I'll return the call to Senator Shoebridge.
Sorry, could I just make 3 points coming off the back of the earlier questions that were asked? So
sure, Mr. Reid, go
put
for
on
it.
the record the answers. So Pete Ratcliffe has an answer in relation to the Ombudsman's report.
Yes, there were 8 suggestions made in the report, 6 of which have been accepted by the Commission and the actions completed. 1 further accepted, and there's an ongoing action which needs to be ongoing because it relates to the destruction of material, which is an ongoing process. And there's a further one that we're still discussing with the Commonwealth Ombudsman about the practicalities of us being able to do precisely what they've asked.
So the next item is that to clarify the Commissioner's salary, it's a total remuneration package which includes super, and that's the 803,440, so that includes super.
Okay.
And then the final one was to respond to the question that I took on notice to check how many recusals has the Commissioner undertaken, and it's now 9. So it was 6, it's now 9, and that takes us to the point where he then is recusing himself from the 31st of October, 1st of November until, well, at this point in time, from all defence and ADF matters.
Thank you for those updates, Mr. Reid and Mr. Ratcliffe. Senator Shoebridge.
Thanks, Chair. So that was an additional, was it, sorry, I was thinking, as a result of the decision that was communicated on the 31st of October of this year regarding Commissioner Brereton stepping aside from all defence matters, as a result of that decision, how many additional matters did he step aside from?
Sorry, so the figures I gave you was between when, I think March, I gave the figure of 6 defence recusals. So from there through to the point where the decision was made to recuse himself from all, there were 3 additional recusals. So that means that's 9 in total, up to the point where he now will not participate in any consideration of any referral.
So there were 9 matters which related to his people he knew, or his work for the IGADF, or his role in the Royal New South Wales Regiment.
Well, yeah, where he
there were
had
9 in relation to those previously identified potential conflicts of interest. Is that right?
So it was where individuals or units he had been involved or actively associated with, predominantly, but there's 9 in total, so 6 to 9.
Okay, so there were 9 of those, and then as a result of the decision that was communicated at the end of October, that the Commissioner would now step away from all defence matters, how many matters has he now stepped away from? How many did that involve?
I think that's one that I'll have to, because there may be matters that he didn't have a conflict with, hadn't recused himself from, and was still maintaining a connection to, that he now will hand over to Deputy Commissioners as part of that 31st of October decision. And so I don't think that I can provide you an accurate number of those tonight, because it'll be matters that are, have been potentially under investigation or still being assessed.
Well, I've got one of those matters that's, I think, still sitting with the NAC. I'd like to know if Commissioner Brereton was involved in it.
No, that's been what's the word? delegated to a Deputy Commissioner, and that was prior to the 31st of October.
That was delegated prior.
Yeah.
But it's a pretty obvious question. It was a significant matter of public interest that Commissioner Brereton was stepping away from all defence matters. You'd agree that that was a matter of significant public interest and comment, Mr. Wright, when it was announced?
Yes, it's a significant step.
And so you come here to estimates, and I ask the very obvious question, well, how many matters did Commissioner Brereton then step away from as a result of that decision? And you can't tell me.
No,
Why not?
not accurately. I mean, I can tell, I'm aware, for instance, the one that you just referred to, that had already been delegated to a deputy, and there's probably others like that, and therefore he wasn't associated with them at the point of saying that he would no longer be involved with defence or ADF-related matters, but they're still defence matters. So I think it is something I have to take on notice.
Well, I want to be clear, Mr. Reid, so we don't go back and forth and there's some, lack of transparency from the NAC. How many matters, defence matters, did Commissioner Brereton step away from as a result of the decision that was communicated on the 31st of October 2025? And I'm talking here in the, amongst other things, correspondence that was directed to the Parliamentary Joint Committee and others. Yeah.
So I'll just have to take that on notice.
You say, but you have been able to communicate a fair amount of information about the extent that the numbers of defence referrals. I think that the NAC sought to minimise the number of defence referrals as a proportion of the NAC's work. Do you remember that?
No, what was said on the 31st of October announcement was that defence referrals are around 3% of all the referrals received, but that doesn't mean that they then all come to the Commissioner or a Deputy Commissioner for consideration, because matters get triaged out or get dealt with at the second stage of assessments and don't come for, decision to the Commissioner or the Deputies.
Well, indeed. So a far more useful figure to understand the extent to which the Commissioner's conflict of interest and potential conflict of interest was impacting on his role as a Commissioner would be the proportion of those matters that involve defence, not just blanket referrals, but the number of matters that have got to the Commissioner and Deputy Commissioner level, because that's where his conflict or potential conflict of interest becomes an issue, isn't it?
So when the NAC Senior Assessment Panel, that's where the 9 number comes from, that in their assessment of and discussions around particular, defence matters, he has recused himself now on 9 occasions from those discussions, and that means that from now on he won't be involved. So,
but there's another unspecified number, you can't tell us how many, that he's now stepped away from in addition to those 9.
Well, that would be the matters that he didn't have a conflict with, that were being still going through an assessment process or had got to the point, because an assessment process can include a preliminary investigation where we can use powers, or full investigations. And so we'd have to go back and look at those numbers.
Well, absolutely. And absolutely the public has a right to know how many matters Commissioner Brereton has pulled himself out of as a result of that 31 October. And further, to get an understanding of what impact that has on the Commission's work, to understand what proportion that is of matters that have got to the assessment.
So because some of those matters were already being dealt with by deputies, they haven't always all been dealt with by that Commissioner. It was identified in that 31st of October announcement that with 3 deputies, the workload will be readily managed from, you know, a relatively small number of matters that have come through the door.
Mr. Reid, how many? How many? What proportion of matters that get to the commissioner, deputy commissioner level does that equate to? And just so as we're very clear, can you provide the number of matters, both defence and non-defence, that get to the deputy commissioner, commissioner level that are in the potential pool of matters impacted by the 31 October decision?
All right, I'll take that on notice, as I've said earlier.
And what's happened to those matters then, where Commissioner Brereton has had a role in defence matters? Maybe he's made decisions on which witnesses to call, the scope of an inquiry, that, you know. What's happened to all of those matters?
Well, the matters, when they get to the point of, for instance, an investigation, there are 7 teams of officers that do investigative work, and there's discussions on a fortnightly basis about those matters, and that involves the deputies and the commissioner. So it's not like there's a lack of understanding of what matters are on the books.
No, perhaps, Mr. Reid, you're misunderstanding my point. If there's a problem of conflict of interest, perceived or actual, and Commissioner Brereton has been dipping his oar into these matters up until the 31st of October, and then chooses to pull... Let me finish the question, Mr. Reid. And then stops on the 31st of October. That doesn't remove the problem, does it? It just highlights that he's been engaged in these matters where there's at least a perception of a conflict of interest up to that point. What's happening to those matters? How do we get rid of the problem?
There was no perception of conflict of interest about those matters because he wouldn't have been associated with them had there been any conflict of interest. 9 recusals. What came of those matters were decided by deputies. So I'm not really sure where you're heading with this. So.
Well, because why did Commissioner Brereton withdraw himself from all defence matters?
Yep, and so it's quite clear in the the November update. It's very clear what the so much paper here. So he stated quite clearly that he's declared and appropriately managed any perceived or actual conflicts of interest relating to defence referrals. However, the recent attention the Commissioner's defence service and connections have attracted in some quarters has become a distraction from the Commission's work. Relinquishing those connections would not remove the potential for conflicts to arise because of the historic relationship. As a result, the Commissioner has decided that he will not participate in consideration of any referrals which involve the interests of any defence or ADF individual or unit that is or comes before the Commission, regardless of whether it might reasonably be perceived to involve a conflict. Those matters will be allocated to the Deputy Commissioner. I think it's pretty clear, the reasoning in that statement.
Public confidence in the NAC has been greatly damaged because Commissioner Brereton has a commission in the Defence Force, has not told the truth to the Parliament about the work that he does under the Commission for the Defence Force, has a number of substantial relationships historic with Defence, and continued to do defence referrals. It was destroying public confidence, wasn't it, Mr.
And that's not what this is saying, and I wouldn't agree with you on that. I think what was becoming a problem was finding the time to be able to devote to all of the work of the Commission that didn't involve defence. There's a lot happening. There's a lot of work that we're managing on a week-to-week, month-to-month basis. And these sorts of interactions here are not helpful in our ability to not be distracted by other things apart from, where we should be focusing our attention, which is the investigation,
Did you have someone else?
assessments and investigation of matters, referrals.
Well, that's a new explanation.
No, it's not.
The time
That's just the
management
reality.
explanation is a new explanation, which we'll look at a little more closely.
Thank you, Senator Shoebridge. Senator McLaughlin.
Thank you, Chair. In your report, you set out a summary of investigations.
Yep.
Are you able to provide that data by department?
We normally don't do that.
Can you give me the reason
So
why?
what we're reporting on there are examples of matters that have reached conclusion or finalisation to give an indication of the sort of work. If we were doing an investigation and complete an investigation, we have to produce a report and that has to be provided to the Attorney-General, and then it can be made public if it's in the public interest to do so. So what we're trying to do is give an indication of the nature of the work that we're undertaking, but we definitely are not making public comments. I mean, apart from this debate going on here about defence, we're not making public comments about which entities within the Commonwealth we're involved in investigating. That's not something that we will do.
I appreciate there's a distinction between what you're investigating and what has been concluded. But how do I know as a senator, for example, there's not most of your work is in defence or most of your work at that high level, not producing your inquiries in health or whatever area, so that I can then argue for a policy response unrelated to your individual inquiries into individual matters. And where does that loop
Well, I think it really only comes when we've finalised an investigation which we may refer to in the annual report, or where we've completed one and produce a public report. We've released 3 statements in our life that relate to matters that didn't get to investigation, where at the conclusion of the assessment process, we made a public statement, in the words of the Commissioner, to clear the air. And so we'll continue to do those. But that's done on a case-by-case basis.
I appreciate you're looking at this from a case-by-case perspective, as is your statutory requirements. I'm looking at it from a perspective that when the journey of the NAC continues, you might be, for a series of circumstances, there may be a department that is particularly, let's just say, non-compliant, right? It may not have a whole series of inquiries that go to full investigation, but there is obviously a systematic issue in a department. Do you supply data in any form, even to the attorney, which would indicate that you have grave concerns because of the number? I don't mean individuals. I don't mean the nature or the sub-department. I mean a heat map. It was what I would have called it in a previous life. Does that get produced by anybody?
So we don't provide that sort of information to the attorney. We would provide information to individual departments or entities where we have a concern about activity that may not have reached the serious or systemic level, but we're seeing a pattern. And we have a thing called the public inquiry power that we haven't used up to this point, but that is the sort of place that you would start looking at not individual cases, but patterns and areas of concern. And so that will potentially emerge, in it may not be this financial year, but in future financial years. At the moment, we're predominantly focused on managing and assessing the referral process, investigating matters and bringing them to conclusion, and we're only really very early in that latter part of the journey, because corruption is very hard to investigate. It takes a significant period of time, and so probably towards the end of this financial year and in the next financial year, you'll hear more about the matters that we're investigating. But if you look at our Act, we're meant to maintain confidentiality around the matters that we are looking at. That's partly to ensure that we don't prejudice any operational activities or unfairly impact on people's reputations. And that's the nature of this world of corruption investigation. And so at this stage in our life, we're not going to be putting out some sort of, comparative table or heat map about which departments.
Thank you. Appreciate under the Act there are powers of inquiry. The Commonwealth has not given the Commissioner a judicial appointment in addition to the powers under the Act?
No.
No.
If we make any recommendations, and we prepare a brief of evidence, it'll go to the CTPP.
No, I appreciate that. In some models, there is an overlap.
No.
I ask out of an abundance of caution rather than
absolutely.
in curiosity. Just to come back to the defence matters which Senator Shoebridge has been pursuing, prior to the Commissioner reclusing himself on the 31st of October, how did the Commission know that it wasn't inquiring into the same issues as the IJDF at the same time as the Commissioner is giving advice to the IJDF? Now, it may be not, but how did you satisfy yourself that you didn't have, because there are two inquiry bodies?
So if we are considering an investigation, the Commissioner was recusing himself from IGADF matters since the 1st of July 2023 in terms of the referrals coming through the door. If we were considering an investigation, one of the sections of the Act, I think it's 54, is it? Rebecca, he turns to. There's a provision of the Act that says we have to take into consideration what other integrity agencies are doing, and the IGADF, 45, sorry, I'm a bit dyslexic, 45, section 45. So we are meant to, and there's a list in section 15 of all the integrity agencies, the IGADF is one of those. We are meant to consider what that organisation may have done in relation to a particular matter and decide, is it in the public interest for us to do any further investigation of the matter if it's already been dealt with by that other agency. And so that's quite an important thing for us to consider. So I'm not sure that what you're suggesting would occur, could occur, because invariably, when matters come through the door, we know what the referral is about, where it's come from. It might be a voluntary one, it may not be a mandatory one, and what the allegations in that referral are, and therefore part of the assessment process is trying to work out what should we do in relation to that.
I'm asking from a sort of process perspective rather than the individual matters. But when the Commissioner recluses themselves, let's say, well, I've given advice to the IGADF, I presume he doesn't say the specifics of the advice, because that would either be under privilege or in confidence, depending on how it's characterised. So other than you knowing that he has given advice to the IJDF and can't see any matter that involves the IJDF, as I understand your evidence, you're relying on the fact that if a matter came that was currently being investigated by IJDF or might be, you would contact them in accordance with those.
We would assess it, and that may involve having to contact them. It depends on what it's about. I mean, we're not going to necessarily contact an agency where it might be about, some very senior parts of that organisation.
Correct.
We'd have to try and make our assessment based on the information. We may ask the referrer for further particulars, and that's very common. And they may or may not be able to provide anything, and then there has to be a decision recommendation made about whether this matter A involves Commonwealth official, B has a corruption issue or likely to have one, and then is it going to get to the serious or systemic level, which is the real threshold test. So there's quite a bit that has to go into an assessment process.
No, I appreciate the assessment process, but do you acknowledge my prima facie concern that you could have a situation, or you might have a situation, where you have the Commissioner giving advice to the IJDF and his own organisation also inquiring into the IJDF itself? And therefore, whilst you may have all the firewalls in place, it does not demonstrate a system which is the public can have total confidence in.
Right, okay. Look, I think what I probably haven't said, and now I've picked up on your question, the advice he's been giving to the IJDF is only about the Afghanistan inquiry that he was the assistant IJDF for, and therefore has particular understandings of what that inquiry looked at, where it ended up, and what the outcomes of that was. So that's what he is providing advice to the IGADF about.
So he's formally declared that to you about the scope of the advice?
Yeah, well, and it's there in the extensions of his the two-year extensions to his appointment. It's also been in the evidence from the actual IGADF on the 9th of October, even though that got corrected as well, that it's very clearly only to do with that investigation, and it will lapse in August next year, because that's when the 2-year time extension, the second one, expires, and it can't go on after that, because it's only because he's Major General in the ADF Reserve that he has the capacity to be able to access records, to be able to make, to provide his advice based on, and his knowledge of, that investigation. It's very clearly that investigation, which is not a NAC investigation. It never will be.
Has he provided that advice to you, or the IGADF has provided that advice to you about the fact that he had to be a Major General active?
That's in the testimony of the IGADF. The reason why the two-year extensions were undertaken, and I think it's pretty clear on the record.
Thank you.
Thank you, Senator McLaughlin. Senator Shoebridge.
Thanks, Chair. I'm going to ask some questions about Operation Kingscliff, but before I do, I just might get on the record what's happened on the robo-debt matter. How much has now been spent by the NAC on Justice Nettle for the robo-debt matter? What's the total amount spent to date?
So the total that's on Oz tender for Mr Nettle is the maximum that at this point. So the Oz tender record is from the 7th of April 2025 to the 28th of February 2026. There was a contract value of $1.138 million. Mm-hmm. And of that, we haven't got to that level. I think the figure that I've got here is probably back sorry, I'm just trying to get to my papers in the middle of other. Sorry. Yeah, wait a minute. Yeah, sorry, I'm just trying to. Oh, here we go. Sorry. What was that? So, I don't know that. I don't think that says it. Sorry, so I can only give you a figure that is to the 18th of September at the moment. I apologise for that. And at that point, there was 334,772 that had been spent, that Mr Nettle had been paid. And of course that has increased since that point. Happy to take that on notice.
Right. But does that mean it's $800,000 for the work from September to February that Mr Nettle is entitled?
There was a total of 1.138 for the contract value through to February next year.
Correct.
And at the 18th of September 2025, only 334,772 have been expended. So there's still a significant amount of money that could be expended, it's budgeted for, that could be expended, and it has gone up since then. I just don't have that value in front of me.
But you see, you were budgeting in September, it appears, to spend $800,000, give or take, on Mr Nettle's services between September and February. That's what you had in the budget to February.
Sorry.
How do you get...
No, I think that dollar value that you're talking about relates to expenditure on Mr Nettle and council assisting.
Well, you said I asked how much has been spent on Mr Nettle and former Justice Nettle, and you said Oztender has the contract at 1.138 million. You said that, and that goes to the end of February, or 26th of February. You said that as at September, $334,000 had been spent. And I'm putting to you that there's the better part of $800,000 then in the contract for 5 months' work from September to February. How do we get? How does someone get $800,000
It's based on a
5
daily
months' work?
rate that was agreed as part of the procurement process, and so he, maybe have not provided us all of his. Invoices. There's an example. I mean,
given time,
sure
Mr. Reid, can I just ask you on notice to identify how much has been spent to date, what the expected spend is?
That.
You said, is there a potential for the contract to be extended past February?
Not at this point.
Yeah. Does that mean the robo-debt investigation will actually end, and 6 years after the totally abusive, corrupt scheme concluded, we might actually get a report?
I can't give you an end date at the moment.
Okay.
This is a request that has come from the investigation team, from the Deputy Commissioner, to extend the contract, because they were contract extensions from 31st of December through to the 28th of February. And we haven't been asked for any further contract extensions.
And just to be clear, every one of those $1 million plus that's budgeted to be spent on Mr Nettle, every single one of those public dollars is being spent because Commissioner Brereton made the wrong call on the conflict of interest. That's the only reason that's spending, isn't it?
The inspector's report from 30th of October last year made a recommendation that we accepted, that because of the apprehension of bias relating to the conflict of interest matter, that the matter should be reconsidered, and we agreed to do that. So we went through that process, appointing Mr Nettle to do that reconsideration. And so that's the reality of where we're at.
I'm going to try and work through a few documents in relation to Operation Kingscliff. But could I start by asking, what's the process for getting an expedited assessment of a referral from the NAC? What do you need to satisfy to get an expedited assessment?
We try and prioritise matters that are, because, you're getting an extreme range of different levels of matters that come through the door, and we have to assess them all. And that's why we break it into triage versus the Tier 1 is triage, Tier 2 is assessment. So a lot of matters don't make it to the point of going beyond that Tier 1, so that's meant to winnow out matters. When it gets into Tier 2, prioritisation is something that we're now doing to try and ensure that significant matters that are clearly likely to be serious or systemic corruption issues get elevated. Otherwise, everything would just take its time to go through.
Serious
So-
matters that are likely to be,
So what we-
significant matters that are likely to be serious or systemic. Is that the test?
And also, I mean, there's an example where in what I've referred to previously in my testimony here, and we've publicly talked about, announced the outcome of, and then a guilty plea and then a sentencing. Operation Pelican actually happened in roughly a week or two from when a matter was reported to us that there was potentially an imminent
So, Mr Reid,
activity around a bribe being sought by a government official. So we were able to activate that fairly quickly.
Mr Reid, I'm just asking what the test is for expedition. There must be a test for expedition that you're applying. What is the test? You said earlier it's when a matter is significant and likely to be serious or systemic. Is that the test?
Well, that's not the exact test, but that's the gist of the test. So
Well-
I'm happy enough to take that on notice and we'll provide you.
How many matters have got through that expedition, been granted expedition?
Oh, I'd have to take that on
Is
notice.
it common?
I'd have to take that on notice.
Is it common? Is expedition common? Is it a thing you regularly do?
Well, we call some of it complex matters to try and ensure that where they are clearly going to take a reasonable amount of time with junior officers, that we try and expedite those along as well. So I'll have to come back on notice.
Well, you start talking about complex matters. Are all complex matters expedited? What's complex matters got to do with expedition?
We're trying to ensure that matters that we have considered to be complex are dealt with rather than being, at
Mr.
times
Reid, I'm
people-
just asking you about expedition.
Yeah, I've
Is there a
answered the
process for
question.
expedition?
I've answered the question. I'll take it
So
on
it's when they're
notice, and
significant,
that's-
likely to be serious or systemic, and you
that's
can't
my-
tell me how many,
that's
but
my
you will on
advice.
notice. Is that the situation?
I've said I'll take it on
Yeah,
notice.
all right. On the 13th of January of 2024, the NAC received a referral from Home Affairs in relation to an investigation that ended up becoming known as Operation Kingscliff. On the 25th of January 2024, you wrote to Stephanie Foster, the Secretary of the Department of Home Affairs, and you said, as requested, assessment of the referral has been expedited and it was considered by the Commission's assessment panel on 18 January 2024. When did Ms Foster or Home Affairs request expedition? And I ask this because I put an FOI in asking for all of the communications between Home Affairs, Ms Foster and the NAC in relation to this, and there's no evidence anywhere in the material produced by the NAC of this expedition request by Ms Foster. So can you tell me when it happened and how on earth it wasn't produced to the FOI request?
Well, I'm not the decision maker when it comes to FOI, but I'm happy to take that on notice because I don't have that level of detail with me.
Well, so you don't know when the expedition request happened? Do you know if it came from Ms Foster?
I personally don't know the answer to that.
Can you explain how there are no records produced by the NAC about an expedition request requested from Home Affairs or Ms Foster about what must be a significant or likely serious or systemic corruption investigation? How are there no records?
I'm not the person that makes the assessment of the matters that were considered as part of that FOI. I'd have to go back and look at that.
All right. Well, you will undertake to do that and explain why no
Well,
evidence
I'll
was
take it
provided.
on notice and see what it is that I can provide.
Was Commissioner Brereton engaging in phone calls with Ms Foster or
I don't know the answer.
You don't know? Are there rules in place for the NAC to record communications that happen between the Commissioner and people who are within the orbit of a corruption investigation?
There's a what's it called? My mind's starting to fail me. There's investigation plans that are put together, and then there are regular consideration of where an investigation is up
Mr.
to.
Reid, I'm not asking about plans. I'm asking if there's record-keeping obligations. If Commissioner Brereton has a chat with Ms Foster, and it turns out, we now know, that it was her Chief of Staff that the investigation was in relation to, if Commissioner Brereton is having a chat with Ms Foster on the phone, is he obliged to keep a record of it?
Well, we have a case management system that we record the activities associated with an investigation, but I don't know in relation to this one what.
If the Commissioner's having a chat...
I've just said...
No, I'm just asking about the system, right? If the Commissioner is having a chat with somebody who is the direct report, the boss of somebody who is the subject of a live corruption investigation, is there a requirement for the NAC, for the Commissioner and the NAC to record the nature of those?
I'm sure that the investigation team would be advised of those things because that's the nature of how these matters progress and how they're discussed.
Well, on what basis was the corruption investigation in relation to Stephanie Foster's Chief of Staff expedited? Why was it expedited?
I'd have to take that on notice.
Who made the decision to expedite it, and was Commissioner Brereton involved in that decision-making?
So, as I said, I'll just have to take that on notice.
Well, you see, Ms Foster had a very active engagement in this investigation about the corruption investigation about her Chief of Staff, because she then later, having been given a draft copy of the report, she then suggests that a bunch of people's identities could be protected, didn't she? She made the suggestion for anonymity.
So we go through, whenever we are drafting a report, we go through procedural fairness, and that involves where comments and other things will be made, we give an opportunity for those people to understand what it is that is going to be said, and they've got the right to raise things. Now, that doesn't necessarily mean that that's acted upon, but it might be. So at this point, I can't answer the detail that you're asking.
Well, at this point, and now we're talking about the 5th of May 2025, Ms Foster writes to Commissioner Brereton, says, "Dear Commissioner," opening sentence, then says this in part, "With respect to your advice that you are considering whether or not to release a public version of the report, I note the statement identifies several individuals other than the 3 protagonists who are involved in the Commission's investigation. There may be welfare considerations for those individuals should their names be released as part of any public report, and I would welcome the opportunity to work with your office on appropriate handling." Did she then work with the NAC on so-called appropriate handling?
I'm not familiar with that level of detail. Sorry.
I can answer that, Senator. No, she didn't.
But she's the one who first suggests that individuals' names should not be disclosed. Was that the first suggestion?
It's something that is considered generally as part of the report. So, but what I can tell you is Ms Foster's comments in relation to that had no influence in terms of the use of pseudonyms.
They had no effect on you. You asked her opinion, you got her submission. Her submission was, be careful disclosing the names, maybe consider not disclosing their names. But that process of asking her opinion and getting her position, you say had no effect on you.
Only because that's our general position, that if you're someone who hasn't engaged in corrupt conduct, that we would take steps to pseudonymise to protect the identity of those people.
But did you ever think that it might be inappropriate asking Ms Foster, because it was actually her Chief of Staff? And you see, by eventually making the Chief of Staff's name anonymous, that was protecting her, wasn't it?
But her comments weren't in relation to her Chief of Staff.
No, but then you used, the Commission then used the argument about protecting those three individuals as the reason why you didn't release the Chief of Staff's name. You used Ms Foster's concerns as the basis for not releasing her Chief of Staff's name.
I wouldn't say it's Ms Foster's concerns. That was one of the reasons, though, that was taken into account in terms of the exercise of the Commissioner's discretion, whether to publish.
And it's just lucky for Ms Foster, is it, that her Chief of Staff's name, following her suggestion about protecting these other three, that argument about protecting the other three is then used by the Commission to also not release Ms Foster's Chief of Staff's name. That was just a lucky bycatch, was it, from Ms Foster?
Not at all. It was one of several considerations that the Commissioner, upon recommendation, took into account in terms of making that decision about whether or not to publish names.
And clearly, page 6 of the report specifically deals with the issue of the use of pseudonyms for protagonists and for witnesses, and it talks about why.
Yeah, it's the reason Ms Foster gave. It's the very reason Ms Foster gave.
Why the Commission made the decision the Commission made.
And it's the very reason Ms Foster gave, isn't it? It's her reason. And you don't say anything about this coming from Home Affairs and Ms Foster.
But the Commission makes its own decisions about these matters, Senator. I mean, you, I think, see a conspiracy behind every matter that we happen to be involved in.
I just see a gross lack of transparency. And this all has to come out through FOIs. At no point in the report does it say Home Affairs sought to protect these the identities of these individuals. Why wasn't that included in the report?
Well, it was the decision of the Commission as to what it did.
You went through and did procedural fairness for a reason, I assume.
Yes.
Home Affairs says, be careful disclosing these three people's names. You then decide not to disclose those three people's names, and in order to protect their names, you also don't disclose the corrupt Chief of Staff of the Secretary, and you don't say that the idea came from Home Affairs. You don't see a problem there.
It's actually probably important to clarify, Senator, that those three people referred to by Ms Foster are different to the three people that the Commissioner took into account. So, for example, we need to be careful in terms of who may have given evidence, who might have been the people who alerted us or alerted the department to the matter. So
she was responding to the draft report. She was responding to the people named in the draft report. Are you saying that those people, different names, got named in the final report, got taken out of the final report to the draft report?
There was a number of people who were referenced, whose names were pseudonyms were applied.
I'm going to show you one more document. And Chair, I'm just going to table those. I will just, for the sake of clarity, table and seek to have published those two documents. But there's one further, yes, that, and I'll provide you another one, which is the document I was just referring to.
Thank you. We'll table those.
Yep. I'll just show you this letter, Mr. Reid. Must be given to Mr. Reid. This again was produced by the NAC under FOI.
Yes.
And this is, the request from Ms Foster was on the 5th of May 2025 for anonymity. This is the 23rd of June correspondence that was then sent to Ms Foster about the corruption findings regarding her Chief of Staff. Have you seen this document before?
I personally haven't, but it's been released by us, so it's
Yeah.
part of our records.
Do you see on page 2, Commissioner Brereton says, further, I've decided to exercise my discretion under section 156 of the Act to publish a version of the investigation report on the Commission's website. An embargoed copy of the public report is also enclosed. I've decided to apply pseudonyms to all persons involved in the investigation, including the persons whose conduct was investigated. Do you see that?
Mm-hmm.
That was in response, wasn't it? The all persons involved in the investigation obviously includes the 3 people identified by Ms Foster. They must fit within the definition of all persons involved in the investigation. Do you agree?
Oh, look, I'm not familiar with this, so...
Well, Ms Foster read their names in the draft report and said, protect their identities.
Yep.
Commissioner Brereton then says, I've decided to apply pseudonyms to all persons involved in the investigation. That must include the people named in the draft report as identified by Ms Foster.
I don't know the answer to that.
Okay, well, can you take it on notice?
Yes.
You then see there's a paragraph redacted after that.
Mm-hmm.
Now, this is in a letter sending the Secretary of Home Affairs a copy of the final report.
Mm-hmm.
Why has that been redacted?
I've got no idea.
What did it say?
What's 47ED? Yeah, we'll just have to take that on notice.
The alleged reason for not providing it under FOI was that it impacts...
I think we'll just have to take it on notice. Happy enough for you to provide the questions and we will take it on notice.
The alleged reason is that providing under FOI that paragraph of the letter that you sent to Ms Foster about what was then becoming a public report, apparently if that's provided, that would impact the operations of the NAC. Are you going to stand by that, Mr Reid, to not produce that?
I'm not the decision maker here, but
I'll make it simple.
It's quite likely that is.
Well, I'm going to ask for you to provide to this committee a full copy of this letter, excluding emails or other
we'll just
personal...
have to take that
Let
on
me
notice.
finish, Mr Reid. I'm going to ask for you to provide a full copy of this correspondence to the committee, excluding emails or phone numbers or other personal contact information, and if necessary, excluding the Commissioner's signature. Will you provide that on notice to the committee?
Well, we'll consider that and take it on notice to consider that.
You'll consider it.
That's right.
Okay, sure. Thanks, Chair.
Okay, are you done with questions for the NAC? Excellent. That means that we are now in a position to release the National Anti-Corruption Commission. Thank you for your time this evening. We will take a short suspension while we welcome our next witnesses, but before we do that, I would like to give a brief update on the program and let the Office of the Commonwealth Ombudsman know that they are also released for this evening.
Sorry, you said also, is there another agency?
Yeah, Office of the Commonwealth Ombudsman, National Student Ombudsman is
that's
released for later on. Yeah.
Thank you.
Broadcasting, and I welcome the Office of the Inspector of the National Commission, Ms Furness. Would you like to make an opening statement before we begin?
No, I don't, thank you.
Music to my ears. Thank you very much. We'll proceed straight to questions. Senator Shoebridge.
Thanks for your attendance, Inspector. Have you been advised by the NAC how many defence-related matters Commissioner Brereton has now recused himself from?
I have asked the Commission to provide me with details and documents of all referrals concerning defence-related matters, and they will include and identify separately those matters in which he has recused himself.
All right.
And I should receive that information later this week or next week.
All right. But sitting there now, you haven't got the information to hand to identify how many of those matters there are?
No, other
Yep.
than, as I think I indicated on the last occasion, the 6 that was referred to earlier, I have those, and I have been told in correspondence that there are additional ones for a range of matters.
Right.
And I have also referred to one of them in my annual report, and I don't believe that's one of the 6, and I can't say whether it's one of the additional 3.
Oh, okay. Well, not one of the 6 that have been previously notified, but you're not in a position to say whether it's picked up in those, the additional 3 we heard about tonight.
No, I
that makes up
suspect
to
not,
the
but
9.
I don't know.
All right. And to be clear, that was a defence-related matter,
Yes.
that one? Yep. Can you give an update on the status of that investigation?
Certainly. I have received to date about 70 complaints concerning complaints generally about the perceived conflicts of the Commissioner in response to defence generally, and in relation to the recent IGADF material that's come to light, and about 17 concerning the procurement issue in relation to council assisting, which I think, Senator, you raised on
Yep.
the last occasion.
Yep.
So I have inquired of the Commission, as I've said, all those defence-related referrals, necessarily including the recused matters, as well as all relevant documents concerning the procurement.
I don't want my questions here to in any way prejudice your independent investigation of those matters, Inspector, so if at any point it does, I'm sure you'll raise it with me.
Certainly everything I have said is already in the public
No,
domain.
indeed. Do you have a timeline for result? That's quite a lot, 70 complaints involving defence more broadly, 17 involving the procurement, but I assume there's some commonality in them.
No.
Is that right? There's not?
No.
Okay. I know it's rude of me to ask this of you, but do you have a timeline for resolving that many referrals?
Well, my timeline has been to request the Commission to provide me with documents.
Mm-hmm.
They have indicated that they will provide me with what I imagine will be quite voluminous documents, either this week or next week, certainly I imagine by the end of next week, and then those documents will have to be reviewed. It is possible, perhaps likely, that I will require more information, and then that will need to be assessed, and ultimately I'll need to come to a view and consult with whoever I have to consult with.
Do you have the resources needed, if necessary, to engage council to assist in this? And I'm thinking about the example of the robo debt inquiry. I think being able to do that was helpful for getting a timely resolution in that matter. Do you have the resources necessary?
I do have the resources necessary, and I have engaged people to assist me.
All right. Have you been provided with any update on the robo-debt investigation? Have you been consulted in relation to the arrangements made in relation to the robo-debt investigation?
I have been updated as to the investigation. Any consultation occurred much earlier on in relation to Mr Nettle.
All right. No, I think they're my questions. Thanks, Inspector. Thanks.
It's very efficient, Senator Shoebridge. Thank you very much. That's all the
Thank you.
questions we have for you this evening, Commissioner. We'll take a short suspension while we welcome our next witnesses. Excellent. I now welcome officers from the Australian Office of Information Commissioner. Before we get to questions and potentially an opening statement, I would like to advise that we are in a position to release the Federal Court of Australia and the Office of the Special Investigator, and I thank committee members for their cooperation in managing the program. Commissioner, would you like to make an opening statement?
Thank you, Senator. I appreciate the opportunity to provide a brief opening statement to the committee on behalf of my colleagues, the Privacy Commissioner Carly Kind and our newly appointed and most welcome Freedom of Information Commissioner, Ms Alice Lineker. Information rights are crucial to our system of democratic government. At the OIC, we are at the epicentre of upholding and promoting those rights in the digital age. The significant increase in the community's engagement with the OIC through applications, complaints and inquiries well demonstrates the importance the community places on their privacy and information access rights. Similarly, government and industry are increasingly consulting with the OIC to inform their objectives of contemporary approaches to governance and service delivery. We are active within our legislative remit across almost 40 statutes in working to meet the new challenges faced as government expands its deployment of technology in service delivery. I'm pleased to advise the committee that our ability to meet these needs is increasing following a year of significant organisational change. During 2024, we delivered a new OIC structure, commenced a program of capability uplift for staff and have focused our efforts on effective enforcement and education to deliver effective regulatory outcomes. Some of the impactful outcomes achieved in 2025 include finalisation of significant privacy matters, including an enforceable undertaking from Meta and Oxfam Australia, the first ever civil penalty in Australian clinical laboratories, commencement of proceedings in matters including Optus, finalisation of 41% more Information Commissioner reviews in 24-25, notwithstanding a 21% increase in applications. In 24-25, we undertook 3 thematic investigations into FOI complaints in relation to non-compliance with statutory timeframes for processing FOI requests under the FOI Act. All of our recommendations were accepted. In 24-25, we determined 248 IC decisions being made under Section 55K of the Act, which is an increase of 20% compared to 23-24, when 207 decisions were made. The issuance of a statement of regulatory approach and regulatory priorities to inject certainty into our areas of focus and transparently communicate these priorities to the community, government and industry, and our success in privacy case management is well demonstrated by a 38% increase in finalisations, notwithstanding a 71% increase in privacy complaints year to date. The age profile of privacy, FOI complaints, together with IC reviews, has improved, notwithstanding an increase in applications. These positive outcomes are confirmed in our stakeholder survey results, with 5 of our 6 measures demonstrating improvements. The key findings include advancing online privacy protections has increased from 60% to 66%, encouraging and supporting proactive disclosure of government information increased from 56% to 65%. The OIRC's regulatory activities demonstrated a commitment to continuous improvement and building trust, increased from 63% to 66%. The OIRC's regulatory activities demonstrated collaboration and engagement, increased from 58% to 64%. And the OIRC's regulatory activities are based on risk and data, rose from 56% to 59%. The OIC's collective efforts are highly credible, and the community is engaging with us at an unprecedented level. The rights we promote and protect contribute directly to a healthy democratic system of government that serves us all. Our regulatory priorities advance the rights we uphold and inject certainty into markets and contribute to a vibrant economy. Through the commitment of OIC staff and the expertise offered under the 3-Commissioner model, we are well placed to effectively discharge our important function as the national regulator for privacy and freedom of information. Thank you, Chair.
Thank you very much, Commissioner. We'll proceed to questions, and I'll start with Senator Blythe.
Thank you very much, Chair, and thank you for that opening statement. I'm just going into Privacy Act reforms and just wondering whether the OAIC can confirm whether it's been advised of the second tranche privacy bill and whether that will be introduced to Parliament.
Senator, I am going to offer that my colleague, the Privacy Commissioner, is available as well, but we certainly have been speaking with the department in relation to Privacy Act reforms. We continue to engage from a regulatory perspective, and I can confirm that my colleague, the Privacy Commissioner, is online, and if, with your consent, if I could ask her if she would like to offer any other observations.
That would be most helpful. Thank you.
Thanks, Liz, and this is Carly Kind, Privacy Commissioner. My apologies if you can't see my camera. I will keep trying to get that working, but I'm here on audio. But to reiterate what my colleague, the Information Commissioner, said, we are in regular contact with the Attorney General's Department about Privacy Act reform. We haven't been advised of any dates or any concrete next steps in terms of legislation.
Okay, thank you very much for that. Are there any specific milestones that you've been asked to meet in relation to stakeholder consultation or any exposure draft review? Have they been given to you?
Thanks, Senator. If I understand your question correctly, we haven't been advised of any process of formal consultation commencing, and likewise with respect to exposure drafts, our input has been limited to advice regarding draft and related questions, but we haven't had any involvement in any conversation regarding kind of external consultation or next steps in that regard.
Excellent, thank you. And does your department take a view on the Tranche 2 policy work and envisage retaining, amending or repealing the small business exemption from the Privacy Act?
The question of what to do about the small business exemption is a matter for the Attorney General's Department, and we've provided our input in terms of how complaints we receive might reflect a need or an absence with respect to the small business exemption, but otherwise we're letting the department take that forward.
Okay, and when you say, I guess, complaints you've received, are there a lot that you're receiving and processing?
I'd have to take on notice the number, Senator, but I can confirm that a certain percentage of complaints we receive don't meet the validity requirements of the Act because the respondent to the complaint is a small business entity. So that does represent a percentage of complaints received by our office.
Okay, that would be great if you can take that on notice and provide that. That would be very helpful. Thank you. And I guess if you haven't started stakeholder consultation or have any sort of timelines, has the government provided you with any written assurance that resources will be provided to you so that you can deliver the reforms when they commence?
Our experience over the last year or 18 months as the government has taken forward the Tranche 1 Privacy Act reforms has been that there is a parallel conversation about the resourcing requirements of implementing those reforms. And certainly when Tranche 1 passed last year, there was an allocation of additional resource for us to implement that. So that is absolutely part of our ongoing conversation with the department.
Okay, but you haven't received anything in writing at this point in time in relation to Tranche 2?
No, as I said, Senator, we haven't received any formal indication that Tranche 2 is moving ahead in that way.
Excellent, thank you. That's very helpful. And I'll just go on to sort of change to a different topic now, looking at some data breaches. So regarding the data breach at Somerville House in Brisbane, how common are breaches of this kind, and how often are schools subject to privacy breaches or cyber attacks?
Thanks for that, Senator. And I might not have all of the statistics to my fingertips, but I'm happy to say that since we were here last time before the Senate, we have launched a dashboard in which we are now making all of the data we receive via the notifiable data breach scheme public, updated every 6 months. But interested members of the public, including yourself, Senator, will be able to scrutinise that data at a detailed level, and we think that's a really important public transparency measure that we're advancing. In respect to your questions, I understand that I only have knowledge of that breach from the media, although I understand it has been reported to our office. I haven't had any statutory role with respect to it, but I understand that it was not an overly technical breach, and certainly I can say that human error, that is kind of non-cyber attack related breaches, do constitute a significant proportion of the data breaches that we process in any given year. I believe upwards of 30%. And educational institutions and schools are certainly subject to data breaches of both types, that is kind of cyber attack related breaches, but also ones involving human error. I would have to take on notice the number of schools that are subject to breaches that we are notified of. And I would also note that there's likely to be some crossover with state-related data breach reporting schemes, and that some state privacy regulators may be the appropriate reporting body in certain data breaches given the state jurisdiction over education.
Excellent, thank you. And then just regarding the leak of the 5.7 million Australians whose data was breached in the Qantas data breach, does the OAIC believe that this constitutes a serious interference with privacy?
Senator, we have received a number of complaints with respect to that breach, including a representative complaint. We have been in a lot of discourse with Qantas with respect to their obligations under the notifiable data breach scheme, which has now been, we're satisfied have been met. In terms of the acts or omissions that led to the data breach, we are still forming a view as to whether or not that warrants our investigation. So I couldn't speak to the substance of your question, but it is we are actively considering whether or not to open an investigation into that matter.
Okay. I guess what's the criteria then for you to decide whether you open an investigation into a matter?
Our statement of regulatory approach and our regulatory priorities set out I suppose, the kind of pillars of how we would consider whether or not to open an investigation into a data breach or into another privacy-related concern. Those include whether a large number of people are affected, and indeed in this case it is that is true. Whether or not the act or practice relates to something that is systemic, that is particularly egregious in nature, in which we can have real effect as a regulator and change market practices, and again, alignment with our regulatory priorities. And all of those things will go into the mix as we consider whether to use our resources to investigate a particular privacy interference.
And so whether data is sold on the dark web doesn't come into play?
But that would inform us as to whether there is harm to individuals involved, and that would be a factor that would certainly be relevant to the exercise of our statutory functions.
Excellent. Thank you so much for that.
Thank you, Senator Blyth. Senator Shoebridge.
Thanks, Chair. Thanks, everyone, for your attendance, and thanks to the Privacy Commissioner for attending online. Good luck in the move. Could I ask about privacy and social media and the social media ban? The OAIC has released privacy rules relating to expectations of protecting individuals' privacy as the social media ban is rolled out. Can you provide a very brief summary of what those rules will mean to young people? Well, pretty much everyone who's going to have their age the subject of inquiry.
I'll do my best, Senator, but as you will know from having, I'm sure, read the guidance, it's quite long and complicated. Yep. But I suppose the key points to take away are that in addition to the Privacy Act applying to the minimum age assurance scheme, there are additional privacy protections that the platforms and any third-party age assurance providers must comply with. Those additional privacy protections essentially put quite a tight grasp around the data that's collected for the purpose of age assurance and requires entities to delete that data after they've used it for age assurance purposes. And at a top level, I suppose, and this really is the main message of our regulatory guidance, puts the onus on the platforms and any third parties to ensure that all of the data that they are collecting is necessary for the purposes of age assurance and proportionate to that purpose, and that we will expect entities to walk that fine line between complying with the regime and not over-collecting or over-retaining individuals' personal information.
So what is the sensitive information and data that is likely to be swept up by platforms, as you understand it, as they go about age verification process? What kind of data are we talking about that is likely to be swept up in this assessment process?
It depends a little bit on the technical mechanism that platforms will use to implement their obligations under the regime. We understand that they're likely to use one of three different kinds of age assurance. Age verification, which involves the collection and validation of identity documents. Age estimation, which involves the use of technologies that can guess or estimate your age from your face or your hand movements. And the third is age inference, in which platforms can use existing data that they hold on individuals to infer their age. And that could be a really broad spectrum of data, from how long you've held a social media account to potentially analysis of the photos that are on your account, to things like, are you logging on near a school, or are you logging on consistently at 3:30 every afternoon, etc. Those three technical implementations of the statutory obligation have different privacy impacts and will involve the collection of different kinds of information. And so that's what our guidance tries to get to the level of offering advice as to how to ensure that if using any of those 3 technical implementations, entities are doing so in a way that is necessary and proportionate.
So obviously requesting ID documents, maybe bank records, it may be identification documents, could even be birth certificates. That there's obvious privacy implications if those are being provided to platforms or assessors. Are you expecting some of that information to be swept up?
Well, the Online Safety Act, Section 63F, requires entities to provide some alternative mechanism for age assurance that doesn't involve the collection of government identifiers. It may be that they offer that as an option, but if they do, they have to offer a secondary option. It may be that it needs to be the fallback option should some of those secondary options not get to the level of accuracy required.
So if a young person is rejected, let's say a 16-year-old is rejected on the basis of age inference or age estimation, the platform can then say, well, actually, show us your government ID and then we'll let you on. Is that how you're expecting that part to work?
It's the E-Safety Commissioner has published guidance which essentially sets out what the reasonable steps to assure age require, and it's not 100% validation of 100% of people. So it would be the case that you would have to look at all the circumstances as to whether or not it is both reasonable and necessary to require government identifiers as a kind of backstop last option.
But it's that very review process, isn't it, of where an initial assessment has rejected somebody based upon an age assessment. A review process is then instigated, government IDs are provided. That's the very privacy disaster that happened with Discord, isn't it? Because it was the review process and all the documents provided for the review process that got hacked on the Discord leak, wasn't it?
As I understand it, Discord wasn't implementing an obligation under this particular regime, but it's correct that it was at the point of review of age assurance that data breach took place, although that was, again, with a third-party provider providing that service.
Yeah, it's who Discord had contracted with to do that. But that's the very kind of privacy risk, the Discord data breach, that I suppose would really engage your office and the Privacy Commissioner with this social media age ban happening. The potential for the exact same data breach to happen here once a whole slew of documents are provided for age verification or ID checking. Is that right?
As I understand it, Senator, the Discord breach wasn't by a third-party age assurance provider. It was by a third-party consultancy service that was doing appeals where they were receiving copies of ID documents via email, for example. I don't anticipate that the social media platforms will be using systems like that because they have had a year to prepare for doing this at scale. I think that my expectation is that there will be more robust systems in place. But I don't disagree that there are, the collection of identity documents in that way would absolutely cause a security and privacy risk.
Now, we're talking about an arrangement that's going to kick in 9 days' time, involving some of the world's largest corporations and about 2.5 million young people. That's the scale of the challenge. How many staff do you have to police the privacy rules in relation to this impending privacy, I was going to say attack, but this privacy issue involving the social media ban? On one hand, we've got 2.5 million young people about, you've got global platforms, you've got complex privacy rules. And on the other side, we've got you in your office. How many people?
We've had a small task force of specialists preparing us for the implementation of the regime, but we have now mainstreamed the expertise and functions throughout the organisation. So I would be confident in saying that all of our staff are preparing to implement the obligation, right from our inquiries line handling staff all the way through to investigations and regulatory action.
How many how many staff is that?
Senator, if I could assist my colleague,
Thank you, Liz.
Thank you, Carly. The ASL for the OIC is 176 staff.
But you're not going to pull everyone off FOI complaints, IC reviews, in order to deal with the privacy issues involving the social media ban. How many people are currently dealing with privacy?
Within our revised structure, Senator, we haven't implemented a domain-specific approach. So my colleague's earlier advice around a task force to establish some of the initial work that's required has also involved ensuring that our complaints managing team, particularly the triage team, are well positioned to be able to receive the complaints, that we have adequate guidance on the website. And as you've heard earlier, our intention is to mainstream but rely upon technology to ensure that we're reporting very carefully against these types of complaints and that we are able to provide good reports, good intelligence to assist us in that regard. And we have updated some of our IT systems to ensure that we can capture this data. I would also say that we did receive funding within our budget to undertake this work by way of a discrete task force to stand up this initiative.
That task force has now completed its work.
The task force is still undertaking work at this time.
But it's not going to be assessing matters. It's not going to be enforcing. It's just trying to work out how to deal with it all.
That's correct, and establishing the infrastructure.
But now, first of all, I recognise that there have been efficiencies in the office, and I see that the Privacy Commissioner in particular, but others, have been dealing with a very large number of complaints. In fact, complaint numbers have increased significantly when it comes to privacy. So there's a lot of work going on. So I understand, acknowledge that work. But when you say that you think you're going to have sufficient resources to deal with the complaints and the enforcement for social media ban, how do you marry that against just the thousands of matters that are now sitting in the backlog for privacy complaints? Those two things don't seem to work for me.
Senator, if I might clarify my response, I can't predict that we will have sufficient resources. We do need to capture this data and to monitor that data. We've had the resources to establish a task force, and that task force has been involved in a program of work which includes a lot of consultation. They've been extremely effective in doing that. Likewise, production of guidance. But in terms of will we see a spike in complaints, Senator Shoebridge, which is I think what you're really asking us, and how will we respond to that, we absolutely do need to ensure that we're capturing that and ensuring that our systems are adequate to support our staff, our guidance is adequate, and then to look at the effect on our caseload overall, and likewise on our ability to enforce action.
But the reason I have very real concerns is when I look at the data provided about the number of privacy complaints on hand, not finalised at the end of each financial year, it hasn't gone up by a little bit. It's basically tripled in the last 4.5 years. It's tripled the number of privacy complaints on hand, not finalised at the end of each financial year. That shows you're already basically drowning in privacy complaints. And they're not small numbers. It's gone from 1,102 at the end of June 2021 to 2,997 on hand as at 9 of October.
Senator Shibridge, you are correct, obviously, in quoting our statistics as to what our caseload is. I would like to call out some real achievements in privacy that have taken effect in the last quarter, and also offer the opportunity in the event that my colleague would like to add to that. But we're now exceeding our KPI for closures, 80% closed within 12 months. And that rate, as at Q1, is at 83%. Staff have undertaken a great deal of work. Whilst our complaints have increased by 79%, our finalisation has increased by 48%. But, Senator, you're quite correct. Yeah. There is a gap between the incoming and the efficiencies.
Again, I'm not critical of the work that's happening in the office, the work of the Privacy Commission. Obviously, a huge amount of work happening there. But if complaints increase by 79%, even if you have a massive uplift in 48% increase in the number you deal with, you're still drowning. And now we're going to have the social media ban come in with heaven knows how many more additional complaints in. And the only additional resources you got are for a task force. This is like a potential disaster, isn't it, in terms of timeliness for you to get to privacy complaints?
Just indicating that I'm going to rotate the call after you've responded to this question.
Senator, my response would be informed by these very new statistics for this last quarter, where we have seen our efficiency in terms of finalising complaints really demonstrably improve, 48% increase. Now, that's
but a 79% increase in complaints.
Absolutely, Senator. I absolutely hear you in terms of the community's interest in privacy, the complaints that they're making about privacy. But it is the first quarter of many changes that the OIC has implemented working with staff to achieve. And in particular, the Privacy Commissioner has been active in looking at how we triage our complaints, how we manage our complaints. And these results, whilst early, are extremely positive.
Thank you, Senator Shubridge. I'll now hand the call to Senator Roberts.
Thank you, Chair. Thank you for appearing again tonight. I've got some simple questions on the data breach by Optus. Could you please confirm the current status of the Office of Australian Information Commissioner's investigation into the major Optus data breach that occurred in 2022?
Thank you, Senator. If I might speak to that, in August of this year, the Office of the Australian Information Commissioner filed civil penalties proceedings against Optus with respect to contraventions of APP 11 that we allege contributed to that breach in 2022. So that matter is now before the federal court.
Thank you. Could you please explain the prolonged administrative inaction, including the handling of complaints CP22/02004 and CP23/00456 that's been going on now for 2 years?
I'm so sorry, Senator. I don't have those complaint numbers before me to cross-reference. Unless you're able to provide me with more information, I would have to take any question on notice.
That's fine. Thank you if you take it on notice. Could you please provide me a timeline? I hear that you've taken the case to court, but could you please provide a timeline for the expected resolution and publication of the findings of your investigation?
With respect to those matters that you've just referenced?
Yes.
Yeah, happy to take that on notice, Senator.
Thank you. Can you provide an assurance that the OAIC's regulatory powers will be exercised independently of civil proceedings?
I'm very confident to provide that assurance with respect to all matters. We operate entirely independently and rigorously in every matter we take on.
Thank you. Last question. Will the government commit to reviewing and strengthening data protection enforcement mechanisms, Minister? Look, I'm very, very worried, and many, many Australians are worried. They're marching in the streets about it. The increased digitalisation just needs one hack, and it can be devastating consequences for so many people. I mean, I've mentioned this so many times in the Senate, outside the Senate, where we've got huge databases linking many, many people, and it just needs one hack and it's gone.
Senator, I'm not sure if you're aware, but the government has committed to privacy reform There's a second stage of that that's being undertaken now. We're committed to uplifting privacy laws because we understand that they're essential for Australia's trust and confidence in the digital economy and digital services, as you raise.
Yes, I'm worried about data protection, though, not just privacy, data protection. What is the government doing about it? Because the consequences now will be devastating. And the majority of hacks, Minister, I understand, are suffered by big tech platforms and government. And most of the problems are breaches of human oversight, undersight.
No, I understand what you're saying, Senator. We passed laws in 2024 as the first tranche of privacy reforms through the Senate. We understand that the Australian Privacy Act is outdated and not fit for purpose for the digital age. That's why we're undertaking additional reforms. And there will be obviously a process for that legislation to be brought to the Parliament, to be considered, to be go through committee processes, I'm sure, which you'll participate in. We're undertaking that work at the moment.
When do you think we'll see the first signs of...
The department might be able to give you some more advice about that work.
People are worried about it. They're terrified of it.
Yes, that's why we're doing something about it.
Senator, so I can say we're working on that second tranche of privacy reform as a priority, with timing will ultimately be a matter for government. But I can also say that the privacy reforms do have a data protection aspect to them, and the Privacy Act contains within it requirements for securing personal information. I'll probably also just highlight that the government has a cybersecurity strategy as well that sort of complements the privacy work.
Now, given that many breaches, I understand the majority of breaches are human error, it's going to be hard to make a bulletproof performance against that, but is there any sign of increased penalties for deliberate breaches or negligent breaches?
Senator, there was some changes made in the last term of government around penalties for breaches and enforcement, and the Privacy Commissioner might want to say more about that. We obviously sort of look at education that crosses both the digital and human error aspects.
And is there any provision, thank you for that, is there any provision for increased access to justice for the people? Because at the moment, so many people cannot afford to go to court. That's just a fact.
I mean, I think this is where the role of the Privacy Commissioner comes in, and Ms Kine might want to say more about her role, but it is that is the role of the Privacy Commissioner to assist in addressing data breaches.
If I might add, Senator, and share your concerns and your urgency, one of the really positive reforms that was adopted by Parliament last year in the Tranche 1 reforms included the ability for the Office of the Australian Information Commissioner to seek orders from the court for compensation for individuals with respect to privacy breaches. We already have the power to issue or order compensation through our own decisions, but we can now also seek them from the federal court in civil penalties proceedings. And I think that goes to the concern you have about remedying privacy complaints for individual Australians.
Thank you, Chair.
Thank you very much, Senator Roberts. Senator Shoebridge.
Thanks, Chair. So to be clear, apart from the task force, which is funding concludes, when does the funding for the task force conclude?
Senator, we have received funding through the 24-25 budget process, which provided us with $5 million over 4 years and $1.1 million per year ongoing from 28-29 to oversee these additional safeguards in the Act relevant to the social media minimum age legislation.
Apart from that, if there's been no additional statutory powers given to enforce privacy, is that right?
The amendment that my colleague, the Privacy Commissioner, highlighted was sections 63F, and
That was that's a fresh obligation in terms of the retention of information, but it's the same enforcement procedures will be used in relation to breaches.
Correct,
Is that right?
Correct.
When we're talking about commencing enforcement actions against some of the biggest corporations on the planet, the likes of, Meta or Alphabet, I think your office has already had experience about the nature and the cost of that kind of litigation. Even one of those cases would run into the millions and millions and millions of dollars, wouldn't it?
Senator, we have received through the budget process additional funding for privacy enforcement litigation as well. And yes, in terms of the expenditure that is required for those processes, it is significant.
So you got one funding increase, you got one time-limited funding increase for one privacy-related prosecution. I think one of the...
Senator, we have also been funded in respect of the decisions of the Privacy Commissioner in relation to Bunnings and Kmart.
Right.
So that has been an additional funding source as well.
But apart from those, it's sort of one-off fundings, there's no pool of additional money to allow you to do targeted prosecutions in relation to the social media ban.
We do have a contingency litigation fund that we draw upon.
How much is that?
Operates, if you just give me a moment, I will look to our litigation fund, which I think is in the order of about $3 million.
But that's to cover all of your potential litigation, isn't it? Not just privacy and social media.
In relation to several high-profile actions, Senator,
right.
And we have been drawing upon that contingent litigation funding.
Have you done any forward analysis of what the additional amount of work is going to be for the OAIC once the social media ban comes in and once age verification is then a widespread experience in Australia? Have you done any analysis of what that work's going to be? Maybe you, Commissioner Kind?
I feel that I should interject, Senator, as I assured my colleagues that they would not be required to speak on my behalf just because I was attending virtually. We have certainly begun planning for an uptick in certain areas of the incoming that the office receives, particularly with respect to inquiries and complaints. And I believe we have already had a number of complaints in about, I think, around a dozen before the commencement of the scheme. So I think that's probably an indication of where that will head. In terms of the resource we're likely to require to robustly enforce the regime and to ensure that we leverage deterrence against those platforms that aren't complying with the privacy-related aspects of the scheme, that will depend on how we see implementation go. We have already written to the platforms to remind them of their privacy-related obligations in respect of particular aspects of the scheme, and then we will be looking to monitor compliance and enforce where appropriate, but it will certainly respond to the need and to how the implementation rolls out.
Thanks, Commissioner. And just on the data, do you know the number of privacy complaints on hand as at today?
I believe we have 3,228 privacy complaints on hand as at the 1st of December.
Commissioner Kind, I know that me reminding you of this is unpleasant, but it's increased from 2,997 to 3,228 in not quite 2 months. That's
indeed.
Commissioner Tidd was saying changes, efficiencies, they've rolled out in the last quarter. Again, I'm not criticising your team. You're obviously producing efficiencies and decisions as rapidly as you can, but you just can't square this circle, can you?
Indeed, we can. I think we can speculate that community concern about and interest in privacy is only continuing to rise, and that is certainly reflected in the incoming numbers, which, as Commissioner Tidd said, have risen by 79% this financial year alone.
Minister, you've heard the data. You can see that the backlog facing the staff at the OAIC for privacy keeps rising and rising and rising. Now more than a threefold rise since 2001, the number of privacy complaints unaddressed. Will your government give this office the funding they need to do their job?
Well, Senator, as you know, we don't make budget announcements or decisions in estimates, but what we have done in recent budgets is announced measures totalling more than $100 million for the Information Commissioner, and that is so it can undertake its privacy and FOI functions. And I know that you are very familiar with the fact that that meant that we could restore the 3-commissioner model. We've also, as the Commissioner has explained, from time to time provided funding for particular litigation that's required. We will go through the usual budget processes as you would expect.
Well, see, your Minister, your government creates these issues. You put the social media ban in, you put the additional privacy provisions in, and then you hand it to a regulator that's already drowning in the number of privacy complaints that are largely being driven to the OAIC because we have 20th century privacy laws in a 21st century world. Like, your government's decisions to either to not fix privacy and to put in experimental projects like the social media ban is what's causing this agency to drown in privacy complaints. That's the truth, isn't it?
No, the truth is that we've provided the funding that the Commission has required over several budgets. The truth is also that we are uplifting Australia's privacy laws. We did that in 2024 with the first tranche of laws. We will continue to do that through tranche 2. And the truth is that the social media ban will save children's lives, and we're very proud of that work, and we'll continue to work with the Commissioner to make sure that we can implement those laws, which we think will make a huge difference to the lives of Australian children.
Commissioner Tidd, have you been given notice of a 5% efficiency requirement from the government?
I'm aware, Senator, that the usual processes for budgetary consideration would be in place and that would be a matter for the department and for government.
Well, the 5% efficiency dividend, to cut 5% is not the usual. Have you been advised of the requirement to have a 5% efficiency dividend from the government?
I've received no formal notification of that kind. I am aware of the AFR article in that regard.
What would cutting 5% of your staff mean?
Well, that's not what...
What would cutting 5% of your budget mean, Commissioner Tidd, in terms of your core work?
Our overall budget is at $40 million. Our ASL is at 176 staff, so it would be the percentage of that. However, that's speculative, if I might add, Senator, in that I have not received formal notification of a 5% reduction in relation to our budget.
Can I deal quickly with the Amex complaint, the now long-running Amex privacy complaint? This has now been 3 years, I think, maybe a little bit longer than 3 years with the OAIC. Has the OAIC assessed whether or not American Express has provided false or misleading information in their submissions and information they've provided to the OAIC?
Senator, I'm just going to assist my colleague online by indicating that matter is still very much alive. It's under consideration. It has advanced considerably, particularly in the last 12 months, and that we have injected and ensured that there has been procedural fairness applied, and that of itself has, to some degree, required us to extend some timeframes. I will turn to my colleague to see if there is anything else she would like to add, but that matter remains under active consideration, and it would not be something that we would discuss to the level of detail that your question seeks to go to, Senator Shoebridge.
Commissioner Kind?
I would endorse what Commissioner Tidd has said. We are still very much in the process of finalising the investigation of that matter, and it wouldn't be appropriate to speak to any more of the details at this stage.
There have been concerns raised with me that the OAIC incorrectly stated that the complainant in the matter sought compensation in their initial AFCA complaint in June of 2022, when in fact, this initially commenced, on my understanding, with the complainant seeking an apology, not compensation. My office has been advised that errors like that have caused significant concern to the complainant. Are you aware of those concerns?
I am, Senator, and indeed I spoke with the complainant in November for about an hour and a half and heard from him all of his concerns and had the opportunity to speak to those. As I said, we continue to work on finalising what is a very complex and serious matter, and we're looking at all of the complainant's considerations. I would also note that there is a complaint to the Commonwealth Ombudsman afoot as well.
Given the nature of the privacy, I'll say breaches, you don't have to adopt that characterisation, involving this matter, the very real personal stress and trauma that's caused the complainant, has the OAIC had ensured that the people engaging with the complainant are properly trained, they have trauma-informed approaches, they understand how to deal with a complainant who's been through this level of distress? Is that part of what's been implemented here?
It is, Senator. There's a series of trainings that our staff receive in this space, and there are a number of mitigations and arrangements that have been put in place with respect to this complainant to ensure we're taking a trauma-informed approach.
Just finally, for the OAIC, and again, I'm sorry, it's to you, Commissioner Kind, are you aware of Proptix.ai and its connection to the former operators of Master Wealth Control and Property Lovers, not least of which is the now struck-off solicitor, Grabisa?
Yes, thank you, Senator. We have been made aware of that new platform by the informant, and we have folded that into our ongoing investigation into property lovers and related companies.
This Proptix.ai asserts that it's operating from Hong Kong, but it's my understanding it's really run by a series of individuals based in my hometown of Sydney who have been associated with Master Wealth Control. Is that your understanding?
I can't speak to the details, Senator, as it is really a live issue that our investigations team is looking at, but rest assured that we have received that information. We continue to dedicate serious time and resource to the property lovers matter and related investigations, and that is a part of those considerations.
Even if it is purportedly being run through a Hong Kong registered company, to the extent that's operating in Australia, Australia's privacy laws still apply to all of its activities. Is that right?
Yes, I can't speak to the specific corporate structure here, but having a foreign-owned company as part of the ownership is not in and of itself a concern in terms of the application of the Privacy Act.
Do you have any arrangements in place with ASIC and as the corporate regulator to address a foreign registered entity operating in Australia, like Proptix.ai is?
In respect to this matter, we have had several lines of communication with other regulators and generally exchange information on an as-needs basis with respect to matters such as this. So we would certainly speak to ASIC and others should the need arise.
See, what we're seeing here is just a new phoenix happening from Ms Grabisa and those associated with that exploitative Master Wealth Control and Property Lovers website. They're now not just phoenixing here, they're phoenixing in Hong Kong and then using that to try and get around our privacy laws and previous enforcement action that you've taken. Have you seen this kind of, overseas phoenixing before?
It's not within my recollection, Senator, of having a matter such as the type you've described, and indeed it would be more likely to be our colleagues at ASIC that have that level of visibility.
Which is why I asked, are you engaging with ASIC to try and see if there's other corporate regulation levers that can be pulled to stop this exploitative team opening up a new business to exploit Australians? Yes, indeed, Senator. I spoke to my team this week about speaking to ASIC and ACCC on this very question that you've raised. All right, thanks. Thanks, Chair.
Thank you, Senator Shoebridge. Senator Cox.
Thank you, Chair. Can I ask some questions around the Children's Online Privacy Code in relation to the consultation process that's been conducted to date? Could you just outline for us what that consultation process has been?
Yes, thank you, Senator. We working back from the date at which the code has to be registered, which is December 2026, we will put a draft code up for statutory consultation in around February or March 2026. In advance of that happening, we ran a more informal consultation with children, parents and the industry throughout 2025. That included the publication of child-friendly materials that were targeted at certain age groups of children and at educators to assist them running conversations in classrooms. We received around 300 submissions from children and their parents in relation to that consultation. We also ran industry working groups to hear directly from platforms and other companies who are likely to be captured by the code, and some other informal ad hoc consultations as well. We've published reports on what we heard from children in brief as part of that consultation and boiled down the main takeaways, and that will inform, or that has informed the drafting instructions we've given to the drafters of the code. And then next year's consultation will be the statutory consultation that will be running for at least 60 days.
Great, thank you. Just in relation to, I'm happy for you to provide that on notice to us, but sort of the range in numbers of stakeholders that you've consulted with thus far. I've noted that you said children, parents and industry. I'd just be interested to know the number and what that range looks like. Happy for you to take that on notice to us. And just in your commentary just then, you talked a little bit about what children have said to you in relation to some of their views. Are you able to give us some examples of what those particular issues are that they feel strongly about when it comes to their privacy protections?
Absolutely, and as my team have done all the work of giving me the numbers here in my brief, I might just read them to you now. With respect to our consultation with children, young people and their parents, we received 161 primary school responses, 74 responses from high school children and 102 responses from parents and carers. In collaboration with Reset Tech, we ran workshops with 57 young people and 70 representatives of academia and civil society. We received 59 written submissions to the issues paper, and we convened 3 industry roundtables with 32 attendees across sectors. And we also met with government agencies, including the National Children's Commissioner, the National Commission for Aboriginal and Torres Strait Islander Children and Young People, and the National Indigenous Australians Agency. In terms of what we heard from children, I'll give you just 3 top-line points. We heard that 70% of children do not like it when information about them is shared without their knowledge. 45% of children do not want location tracking on by default and want to be notified when and why their location is being tracked. And 60% of children want more control over their personal information through the right to access, update and erase their personal information.
Great, thank you very much, Commissioner. What are the key features of the proposed code that's been discussed with these stakeholders? Are you able to tell us a little bit more about that?
I certainly can speak to it at a high level. So the mandate we have is to develop a code which is not inconsistent with the Australian privacy principles. So they are our starting point, but we consider that mandate to enable us to develop higher and stronger protections for children that are already existing in the Privacy Act. We're looking at things like requiring child-friendly privacy policies, better transparency and communication of information to children in a way that meets their requirements and capacities. we are looking at how entities should consider the obligation to act fairly and lawfully when collecting information, and how that interplays with things like nudge techniques. And, you know, as a preliminary view, we would consider that nudge techniques wouldn't amount to fair and lawful collection of children's information, for example. We're looking at direct marketing, and indeed we're looking at children's desires around erasure and deletion of their personal information and how we might give effect to that within the confines of our mandate.
Great, thank you, Commissioner. And as a mum, it's such a great piece of work, and well done to you and your team. Where are you currently at in terms of the process, and what are the proposed next steps? I know you outlined the draft code. Are you able to give us any more ideas of what's further down the track in the process?
Absolutely, Senator. And as you can see from our approach so far, we've tried to be really informed by children and their parents. And so when we publish the draft code, that will go out, of course, to the regulated sectors, who will no doubt pore over it with a fine-tooth comb. But we will also be publishing a child-friendly version of the draft code so that we can consult with children. And my team are exploring a range of creative ways to do that, including with collaboration with partner institutions, and we hope we'll get a lot of incoming feedback on the draft code before we're finalising it next year. We will also be undertaking a regulatory impact study as well to understand the impost that the code is likely to bear on the regulated sectors.
Excellent. Thank you very much for your time, Commissioner. Thank you, Chair.
Thank you, Senator Cox. That's all the time. That's all the questions for tonight. I'm sure that you will receive a number on notice, but thank you very much for your time this evening. We will take a short suspension while we welcome our next witnesses to the table. Broadcasting, and we will welcome officers from the Administrative Review Tribunal. Mr Hawkins, would you like to make an opening statement?
I'll waive an opening statement, then go straight to questions.
Yeah, I don't think your microphone's on.
Yeah.
Or mine.
There's no microphones on. Can't hear anything.
Testing. I think I'm back on now.
Good to go.
Excellent. Welcome, Mr Hawkins and the Administrative Review Tribunal. Would you like to make an opening statement?
Michael Hawkins, CEO and Principal Registrar of the ART. I'll waive an opening statement and submit straight to your questions.
Appreciate it. We will proceed to Senator Scarr.
Mr Hawkins, Registrar, how are you?
Very well, Senator. Yourself?
That's good. So I want to pursue some questions in relation to how the ART is grappling with the huge workload at the moment, and I appreciate the workload and I appreciate the pressure everyone's under as well. So if I can convey my my regards to you and your team. Last time we spoke, my recollection is that you estimated that the ART was still seeking to recruit approximately 100 full-time equivalent members for which you'd been funded, but who you were in the process of attempting to recruit. So I was looking for an update in that regard first.
All right. So, Senator, we are funded to finalise 71,045 applications, and that is with a budget of 430 FTE of members. Now, as at 31st of October, according to our pay run, we have 281.2 FTE of members. However, an additional 27 members representing 21.6 FTE commenced on the 27th of October, but evidently hadn't been paid in that pay run. An additional 37 members representing 29.3 FTE have been appointed and will commence in January, February and June of 2026. Therefore, we are short 97.9 FTE against our budgeted FTE of 430.
Okay, so that's still an incredible shortfall. Secretary, can I ask you, is the department aware of the shortfall, and from the department's perspective, what assistance is being provided to the ART with respect to recruitment and addressing this shortfall?
Thanks, Senator. There's obviously been a huge amount of activity recently in relation to appointments to the Administrative Review Tribunal in terms of recent appointments that Mr Hawkins has referred to, as well as work to support future appointments. But I might ask Ms Harvey to talk to some of the detail there.
So, Senator, there is, in addition to those appointments that Mr Hawkins referred to, there's a current process on foot as well. So there was a process advertised in late August, and just had, I think, something like 3 weeks' worth of interviews being conducted. So though that process is well underway, and will support an additional number of appointments. So we are very conscious of the need to continue to be recruiting members to the tribunal and continuing to undertake a significant number of recruitment activities.
Okay, thank you. Registrar, how many cases do you have on hand now? And feel free to use the last convenient date, because as at 30 June 2025, it was about 112,000. So what's the most recent information you have?
31st of October, I think it's 124,000.
124,000.
Mm-hmm.
Okay, so it's gone up by more than 10%.
It has.
In 3 months.
Which is commensurate with the increase in lodgements, obviously.
Okay. And then just going through a number of the different lists that you run, in relation to the migration jurisdiction, you had 56,698 cases on hand as at 30 June 2025. How many cases do you have on hand?
69,903, representing 56% of our caseload.
Okay. The protection jurisdiction?
40,413, representing 33%.
So just between those two caseloads, you've got nearly 110,000 cases, correct?
Yep.
Okay. So one of the areas where you had an explosion in cases, I think a 1,500% increase over a number of years, was in relation to review applications in relation to student visa cases.
Correct.
How many cases do you have on hand now in relation to student visa review?
46,590, representing 38% of our caseload.
46,590?
Correct.
Okay. And do you have breakdowns in relation to what sort of granularity can you give us in relation to the types of those cases in terms of country of origin of the applicant, in terms of the nature of the decision, whether or not it was the first application for a student visa or an application for a subsequent student visa? What sort of granularity can you provide?
No real granularity in the study visa. In protection visas, for instance, I could give you country of origin for those.
Okay. Well, let's just stick with student visas for the moment. What's the most up-to-date statistics with respect to the results of the reviews which are being conducted by the ART in terms of whether or not the reviews have been successful, not successful, remitted back to the original decision maker? What sort of granularity can you give us in that regard?
All right. In student visas?
Yep.
I can tell you that 44% of outcomes resulted in a changed decision.
So what period's that for? So
that's 1st of July to 31st of October.
And how many decisions in that period? So we say 44%, but how much is 44%?
Let me just see. 6,800.
Sorry, no, sorry.
Well,
It's just students, 3,886.
3,886.
3,886. Resulted in a changed decision?
No, that's total finalisations.
Oh, okay, so 44% of that?
Correct.
Right. Okay, and what's the... I mean, it's a bit hard to ask you for a median processing time given there's been an explosion in these cases recently, but is there any data you can helpfully give us in terms of the period it's taking to review these applications?
So, yep. It is difficult to break it down into meaningful numbers, Senator. So, as at 31st of October, we've got 33,113 that are under 12 months.
Under 12 months?
Yep. And 13,348 that are within 1 to 2 years. And as you say, that is consistent with the explosion we've had in that period of time.
And do you, what sort of triaging are you doing in relation to the cases? So I know in the past we've had discussions about how you've been diligent in trying to address long-standing cases and using additional members to address long-standing legacy cases, but what sort of triaging are you engaging in?
In the study space?
In the study
visas?
visas? Well, just on study visas at the moment, in the study visa space.
Okay, well, there's not a lot of triaging going on because we simply don't have the resources to attack the study visa cohort.
Okay.
I can give you a much cheerier story in the backlog of protection cases, however.
We'll stay with the... we'll end on the cheery story, Registrar, but we'll just...
Flag him and need to rotate the call.
Yeah, okay.
Is it now a good time to do that?
No, if I can just finish on the study visas, I'm nearly finished on those.
Yep.
And then come back to me. Yeah, but I'll need another block. For student visas, yeah, just 2 minutes. Okay, so... how many members of the ART, you've got someone who presides over the student visa list, as I understand it. So how many members are allocated to dealing with those cases?
I'm not sure that I've got that data. I'm just going to... Could
please.
I ask the team to consider that?
Oh,
and
absolutely.
Come back to your next block?
Yeah, if they could. So I just want to feel for, out of your total FTEs, how many... What proportion are dedicated just to dealing with this horrendous number of student visa applications? Okay.
What I can tell you, though, Senator, is that of the 97.9 FTE that we're looking for, the vast majority of those will be dedicated to student and protection visas.
Okay. All right. Thank you.
Appreciate it, Senator Scarr. Senator Shoebridge.
Thanks, Chair. Nice to see you again, Registrar. Always a pleasure. And I won't go over the data about the backlogs, but if you recall on last occasion I asked if you were having dialogue with Home Affairs to try and resolve their internal decision making, which seemed to be driving such a huge amount of your workload. Have you had that dialogue with Home Affairs?
Senator, we tend not to have dialogue about what's driving their decisions other than their resourcing, that they've been resourced to make more decisions. I'm more driven in my communications with them about what our pending caseload looks like.
But for example, as I understand from Home Affairs, one of the reasons they say a large number of matters are being remitted are because they make decisions, say on student visas, rejecting the visa because certain documents haven't been provided.
Correct.
A review application is then lodged with the ART. The documentation is then provided. It's then remitted back to the department.
That's
and
right.
the visa is approved. That seems to me almost the definition of ridiculously wasteful triple handling. Do you endorse that proposition of ridiculously wasteful triple handling?
Not for me to comment on policy,
Yep.
but it is certainly frustrating. So our student visa caseload operates effectively, as I answered to Senator Scarr, 44%, but it's usually between 44 and 50% get remitted. About 30% get withdrawn, and that's through our triage process that the Senator referred to, and 20% get affirmed.
Yes. And in that remittance rate, 44 to 50% remittance rate, across the work in the ART, that's an incredibly high rate, especially given the volume.
It's extraordinarily high and probably comparable only to the partner and family visa cohort.
But both workloads that come out of the same department.
Yep.
Secretary, your agency, and I mean that in a generic way, but the ART is in your patch.
Yep.
It's been given this incredible caseload, huge amount of public resources being spent on it, impacting the rest of their work, because another department, in this case Home Affairs, has chosen a decision-making process that effectively hands this workload to the department. And you heard my characterisation of the process. Are you engaging with Home Affairs on this?
We around matters that affect the ART and the court's jurisdiction, we engage with other departments, including the Department of Home Affairs. There's a couple of things that I would say. I note that there's some legislation in the Parliament at the moment that goes to enabling more efficient processes for in what potentially in this category of student visas, and we would be hopeful that legislation can progress through the Parliament next year. In terms
that's
of
the
the
ambulance
specific,
at the bottom of the cliff. That's the
sorry?
ambulance. That's more ambulance. That's dealing with it, making a more efficient ambulance at the bottom of the cliff. If Home Affairs had a system in place where they said, well, look, we're going to refuse your application unless you provide the following documents, and they give people an opportunity to provide documents, that'd be putting a fence at the top of the cliff and stopping this huge workload coming to the ART.
I would say we should seek to tackle it in both ways. As I said, we do engage with Home Affairs, and I think listening to the detail that's just been provided there, I would like to undertake to raise it myself with Home Affairs.
All right. Good. Thanks, Secretary. Registrar, you recall on the last occasion there was quite a significant amount of discussion about people's entitlements, their personal leave entitlements and their personal entitlements, which were dramatically reduced as they moved from the former AAT to the ART. Do you remember that?
And I hope I've answered your questions in your quans to that effect.
Well, there have been some answers to my questions on notice, but I asked if complaints had been made and raised with you in the ART about this, and your answer was equivocal. I didn't get a clear answer about complaints having been raised. Have complaints been raised directly with you or to the ART that you're now aware of in relation to this leave issue or the personal leave issue?
Okay, so I did respond to one of Senator Scarr's questions where he invited me very kindly to check some information that I provided to the committee. I had in fact received a letter from an association called Professionals Association that had raised the issue of leave and why
Is
had
that
it...
Professionals Australia?
Professionals Australia, sorry, yeah. To which I had responded again, which much the same answer as I'd given you, is that leave, personal leave in the AAT was not an entitlement, it was notional, and the transitional legislation from the ART referred only to the carrying over of entitlement to leave, which was recreational leave.
Will you provide to this committee the correspondence to and from Professionals Australia in relation to this matter?
I can't see any personal information in it that would prevent me, so I can do that.
Did Professionals Australia raise concerns about the behaviour of the ART in not crediting that leave being a breach of the national employment standards?
Yes, they probably did. I think they also referred to not being in accord with community standards as well.
Yeah.
Sorry.
I'll ask this question and you can put any additional context you need, Registrar. Have you got advice? Have you received advice addressing that concern that the not crediting of leave was a breach of the national employment standards?
I can't say that I specifically had advice on that point. I just had advice on the interpretation of the transitionals.
Well, you see, Registrar, it does trouble me that if you've been put on notice that not bringing over people's leave entitlements is a breach of the national employment standards, I would have thought it would be incumbent on any federal agency to get advice about whether or not they have complied with the national employment standards, particularly given this is a complaint that, if it's come from Professionals Australia, has come from a registered industrial organisation which normally knows its stuff.
To which I'll add, Senator, I've had no response from them to my advice to them.
Did you say to them that you understood that it was compliant with the national employment standards?
No, I didn't address the issue of NES at all. I just said we had advice that confirmed that in accordance with the transitional requirements of the ART Act, that personal leave was not transferable.
Well, that may be how that particular Commonwealth provision operates, but if there's a national employment standard that says you can't do that, that would be relevant, but you haven't received advice on it. I'm happy if Mr Crew wants to...
No, he's just advising me that we took advice on that letter, which we did, but it addressed the issue of the transitionals. Yep. But I think it also referred to the fact that members are not employees.
Well...
they're statutory appointees, they're not employees.
Well, could you... can you guarantee that what has happened in relation to tribunal members' leave entitlements is not in breach of the national employment standards?
I'll take that on notice, but as I've said, the advice I've got is that members are statutory appointees and are not employees for the purpose of workplace laws and our enterprise bargaining agreement.
And have you received advice that these entitlements are not covered by the national employment standards?
I have not specifically got advice about the NES.
Minister, whether or not members are expressly covered by national employment standards, and I'm not asking you to form a conclusion on that, the national employment standards are a pretty good basic standard, aren't they, for how you should treat people who work for you with dignity. Do you agree with that?
No, of course they are, but we also know that there are, under particular acts and even, I would say, throughout the public service, examples of people who are employed in a different way. Statutory appointments are one of them. I don't have advice in front of me around this particular employment arrangement, and given our past lives, you know, I'm not going to give you advice at the table without having something more in front of me. No. But to say that what the registrar has explained to you is that there is a different form of employment here, and I can take on notice whether we have any other further advice.
Thank you.
Thank you, Senator Shoebridge. Senator, okay.
Thank you very much, Chair. Thank you for being here this evening. Mr Hawkins, my questions start with you at least. Could you please provide an update on to the committee on the current status of the migration backlog?
I did provide some details to Senator Scarr. Was there information above that you'd like?
I was actually out of the room, I think, when you gave that evidence
Can
recently.
I give you
Just to assist my colleague, Chair, Registrar Hawkins gave some advice with respect to the protection, onshore protection review backlog and also student visa backlog, but I don't think you gave any other statistics, Registrar.
I gave you a total cases on hand as at 31st of October for migration is 69,903, which represents 56% of our entire caseload. Would you like a breakdown of the 2, 4, 5 visa types that makes that up?
Yes, thank you.
All right. Character and citizenship are 529. Family and partner, 5,218. Study visas, 46,590. Visitor, bridging and other visas, 5,234. Working, skilled and investment visas, 12,332. And then I could, if you wish, give you a breakdown of protection visas by country, if that's of assistance.
I might get that one on notice if I can, because I'm mindful of the time. I just wanted to thank you for the breakdown there. That's quite interesting to see what's happening in that space. Do you have data on the current clearance rates?
Yes. In migration? Or across the tribunal?
Across the tribunal.
Okay. Yep. All right. So migration, the clearance rate is 28%. Protection.
Yep.
As at 31st, I'll be consistent. As at 31st of October, the migration clearance rate is 34%.
34, not 28.
Yeah, sorry.
Yeah, that's okay.
Okay. Protection clearance rate is 141%. Our general jurisdictional area, which includes child support and information, is 84%. Intelligence and security, 100%. National Disability Insurance Scheme, 72%. Social Security, 114%. Taxation and business, 122%. Veterans and workers' comp, 118%, representing a total average of 65%.
Okay. If you could, on notice, give me the clearance numbers per month.
No, I wouldn't have that data. I'll have to take it on notice.
That's fine. If you could do that, would be great.
How far back, Senator?
I might get you to, on notice, take that question back to the commencement of this parliamentary term. It's arbitrary, but, it's useful.
All right.
So,
would it be easier if I took it back to the commencement of the new tribunal, 14th of October 2024?
Okay, it will. If that's easier, do that for me. If there's any way you can cut it at a certain point so I can look at the data.
Sure.
For this parliamentary term, that would also, if you give me the indication of the cut-off date, then I can work from there. Thank you very much. So, 122, 118, 141, 100 and 114. Some areas looking like they're going along gangbusters. I was in the room when you were giving numbers of how many people you have currently engaged and you're increasing your capacity to increase the clearance rates. What's the ambition for the number of matters to be cleared by the end of this year, 31 December 2025?
Our target is 71,045.
So another couple of thousand between now and the end of the year?
Across the tribunal. Sorry, total finalisations, 71,045.
Okay.
Now, whether we will achieve that will be dependent upon the number of members we have to finalise.
Okay, thank you. With regard to the status of the aged care load for protection visas, what's the status of that?
Let me see, 3 plus. Oh yeah, great. Right, protection. So, over 3 years.
For the aged care load?
Yes.
Yeah.
Of protection visas over 3 years is 12,929.
And what 3-year period are we talking about, from what date to what date?
This would be as at 31st of October.
Back 3 years.
Matters that are 3 years or more.
Okay. Yep.
Okay. In the 2 to 3 year category, we have 7,283.
Yep.
1 to 2 years, 8,177. And less than 12 months, 13,088. So I might add, Senator, for your interest, we had a cohort of members appointed from September 2023 to February 2024, which were roughly about 85 FTE, committed to our most aged caseload. And during that 2-year period, we managed to reduce the 3-year plus caseload by 63%. Now, moving forward, we will have a dedicated resource equivalent to 85 FTE who are committed, I have committed the tribunal to clearing 38,100 matters in both protection and migration, to bring our caseload in protection that there will not be, from that number, any cases older than 12 months.
How confident are you of achieving that outcome, Mr Hawkins? Because, I mean, the reality of all this, we're talking numbers, and there's really huge numbers. But for every person who's one amongst that number, there's a whole lot of people who love them and care about them and want matters to be resolved. They all want what they want, but you know, I'm sure that many of them would just like to get these matters settled and not be in this permanent limbo. So,
Senator, to give you an answer to that question, I'm not sure whether you are, but certainly some of the others are familiar with the fact that I used to be a member in the protection caseload. I understand that of the caseload, 10% of those applicants are probably entitled to a protection visa. It motivates me every day that we find those 10% so that they have security and certainty over their status. But in order to get to that 10%, we have to go through the 90% as well.
yeah, and the clarifying for those people as well.
Correct.
And not perhaps the outcome they want, but at least it's a clear decision so that there's no ongoing uncertainty.
Correct. And I feel the same way about all the visa classes, but particularly the partner and family visas, where we have people waiting to reunite. So, yeah, that's what motivates me, the President, the tribunal leadership, is to get through these cases. I'm grateful to the government for the funding they've given us to fund the backlog, or backlog members, as we colloquially refer to them as. But that's why I've set that lofty target of 38,100. And that number was set as at the 1st of July 2025. So it's that caseload from 1st of July 2025.
Well, a shame that we ended up in a situation where there was such an incredible backlog, but good to see the investment from the government getting on with the job. Thank you.
Thank you, Senator O'Neill. Senator Scarr.
Thank you, Chair. Registrar, you talk about that target you have of approximately 71,000 cases.
Yep.
to be resolved by the end of the financial year?
End of financial year.
Right. But that is predicated, isn't it, on you having that additional 97 FTE?
On us being properly resourced.
Which assumes an additional 97 FTE
Yes,
based on your current numbers?
Yep.
Okay. So if you don't have that additional 97 FTE, then presumably it necessarily follows you're not going to close out that number of cases because you simply don't have the resources.
Yeah. I think you referred to it last Senate estimates as clever accounting.
Oh, okay. Did I?
Yeah, sounds like that.
Sounds like me, doesn't everyone? Yeah, I'm piling. Thank you for that, Registrar. Can I ask you, in terms of the protection visas,
yes.
And I noted your comment about finding the 10% who are entitled, and I couldn't agree more with your observation in that regard, and I know your sincerity as well in that regard. What is the current success rates or review rates in terms of successful reviews, in terms of that protection workload?
I think I did provide that to you in a quan.
Yeah. Do you have any updated figures?
I think the numbers that I gave you were pretty accurate. So 21-22 it was 7%, 22-23 it was 11%, 23-24 it was 9%, 24-25 it was 11%, and to the 30th of September this year, it's 9%.
Okay. And do you have that breakdown? Do you have breakdowns in relation to countries of origin?
I'm sure I do, but I don't have it with me, but I could take that on notice for you.
Right. Could you take it on notice? So I'm very interested to know what the review success rate is on the basis of country of origin.
It is variable.
Of the applicant.
Yep.
And also the number of cases you have based on each country of origin. So, Registrar, you say it's variable. Is there any indication you can give us this evening with respect to the level of variability?
I can't give you numbers, but I'll just say, off the top of my head, countries like Afghanistan are obviously going to have a high remit rate. Sorry. Other countries, perhaps China or India, may not be quite so high.
Okay.
Would you mind if I just ask a question on that?
Yes, just a second, Senator. I may have some information here for you. I just want to check that we're accurate. Oh, yes. So, you got your pen?
Yep, I do.
Okay, so China. Now, what question do you specifically want, Senator? Is it numbers affirmed or numbers set aside? Set aside?
Well,
what's set aside is where they get a visa.
Successful reviews, so they're set aside.
For an applicant?
Yeah.
Oh, okay. So this is from 1st of July to the 31st of October. So for China, no. Sorry, this is not accurate. I will have to get it more accurate because it's jurisdictional area, not necessarily country. Sorry, I will have to, that's jurisdictional area. Yeah. Yeah, but that's
what does jurisdictional area mean?
Sorry, analyst. So we divide up our jurisdictional area into lists for management of member purposes.
I'm happy to get those figures if you've got those figures. So I know you do divide into lists, and then if you want to give me further
Senator,
granularity.
I can give them to you, but I've got to tell you they're meaningless because this is we put members in lists for management purposes.
Right.
So a member in the China list, for example, may not be doing China cases.
Oh, okay.
All right. So honestly, it is a meaningless number, but I will get those numbers for you.
Yeah, if you could, that would... Sorry, did Senator Shoebridge, you had a...
Were you done?
No, I'll come back to it. No, you finish, I'll come back to it.
Oh, okay. All right.
I appreciate the negotiation across me.
No, sorry, Chair. Sorry, Chair.
It's late.
I should have...
Subject to what the Chair says, I'll complete my...
Or something brighter.
Don't lead me... through you, Chair, don't lead me astray, Senator Shoebridge.
And Senator Scarr, I will have to come back to you on notice of the question you asked me before about student visas. I don't have that breakdown.
Oh, okay. All right. Because I'm interested, just again, country of origin and success rates would be very useful. How do you triage from an ART perspective in that regard? So you made the comment, Registrar, that there are different success rates from different countries, and all the publicly available information tells you that in terms of onshore protection claims, applicants from Afghanistan, Syria, Iran, Myanmar, DRC will potentially have higher success rates than, say, applicants from Samoa, Fiji, wherever. But how do you triage?
So we don't triage for success. We'll triage for country. We'll triage for claim types. We'll triage primarily as to whether they have jurisdiction. And if they don't have jurisdiction, it'll go down a certain pathway to registrars. We'll triage as to whether they're still in the country. And that'll take a separate pathway. We will engage with applicants. We've received, as you know, powers for registrars in the legislation and in authorisations and rules to enable registrars to seek information to speed up the process of getting a matter to a member for a hearing. So that's more the nature of the triage. It's not so much success-based.
Okay. You mentioned still in the country. How many of the protection visa review applicants are outside of the country?
Well, if they're outside the country, they're not entitled to a protection visa.
So it's a jurisdictional issue?
Yeah, correct.
Right, okay. Okay. And in terms of the, I can't remember if I asked you this, in terms of the other migration cases, do you have the success rates in terms of decisions set aside, so say the character and citizenship, family and partner, etc.?
Just get the information from my statistician. Okay, yes. So, character and citizenship, this is where decisions are changed.
Yep.
35%. Family and partner, 52%. Study, 44%, as we discussed.
Yep.
Visitor bridging and other, 23%. Working, skilled and investment, 45%.
Do you have any further granularity in relation, and maybe you take this on notice, in relation to the visa, visitor bridging and other, and the working and skill?
May I take that away and I'll
can.
provide some data.
Okay. And my last question, when you talk about clearance rate, can you just define how you calculate the clearance rate?
Clearance rate is finalisation as against number of lodgements. So if we have 100 lodgements and we have 100 finalisations in that year, it's 100%.
All right. So
it doesn't mean that it's those it's those lodgements in that year that are cleared.
Could be the.
I wish it were.
Okay, understood. So it doesn't mean that. Okay. So it's saying that you're only looking at a year's worth of lodgements.
Yeah.
In terms of the denominator.
We've had this discussion before, Senator. You've asked us about why our period of time over clearance was reducing, and it was because we were clearing those very aged cases.
No, that's right. Okay. All right. So when we get a figure of 141%, say on the protection visas, that...
It's because we've had that dedicated FTE clearing those most aged cases.
Yeah, but you're only looking at the denominators, only the cases lodged that year.
Correct. Yeah. Which is growing, mind you.
Which is growing. Yeah. Okay, understood. Thank you very much, Chair.
Thank you, Senator Scarr. Senator Shoebridge.
Registrar, you offered to give the number of protection visa applications on hand by country. If it's a list of 132 countries, I don't want it now, but if you could provide the top 10
20?
or 20, that would be terrific.
Sure.
Are you able to,
I don't have it with me, but I will certainly provide that to you.
All right. Well, if you're doing it on notice, then if you could just do the full list on notice, that would be helpful. You said that the set-aside rate for visa applications from Afghanistan is significantly higher than from China. That means, doesn't it, that the department, the Home Affairs is refusing a higher proportion of applications in relation to Afghanistan than in relation to China?
That would be a moment in time as well, Senator.
All right.
So obviously we're aware that country information from Afghanistan might now indicate that it's a significantly more dangerous place to go home to than it might have been at the time the application was made.
Well, are you able to give some historic data in relation to that, the set-aside rates by country going back, say, over 5 years, so as we can get a sense if
that information is available to me, I'll have it.
Yep.
You may have it.
Thank you, Registrar. Are you also able to look at your workload by agency? So you've got a certain amount of decisions that are generated from Home Affairs, a certain amount that might be the AG's department.
Social Services, NDIA.
Social Services, yeah. NDIA. Can you look at it by can you cut down your
set-aside rates?
Set-aside rates by agency and numbers?
Yes, we can.
Yeah. I think that would be really helpful to get an understanding of...
I think I'm setting myself up for a lot of questions next time we meet.
Well, yep. I'll be quite frank. I'll
provide that to you.
Family and partner visas, when you are having to set aside more than half of the decisions that come out of Home Affairs on family and partner visas, things that are so incredibly personal to people, to bring their partner, to bring their parents, to bring their kids... When you're having to set aside more than half of them out of Home Affairs, for me that's not indicative of a problem at your end. That's indicative of a problem being fed in from Home Affairs. But do you have any reflection on what's causing that?
In partner and family visas, Senator, it can often be a moment in time thing as well. By the time we get to them, they may have been here for 3 years, but they've been able to make their case stronger for the permanency of their relationship, for example.
Well, if you can shed any light on why it is you've got such an extraordinary set-aside rate for partner and family visas, I would appreciate that on notice. Right.
But it is, they would be systematic of that, where a relationship has proven to have stood the test of time. They may have had children as well in that period of time, which would suggest that the family unit is intended to stay together. You
might then also tell me how long those matters tend to be with you.
Sure.
From the time the review happens to when you make a decision. If it's 9 months or 12 months or 2 years, what the actual time frame is for decisions, which might give some indication of that.
Sure.
Thanks, Chair.
Thank you, Senator Shoebridge. That's all the questions.
Could I just make
a correction?
Jamie Crew, Chief Operating Officer, I handed Mr Hawkins some numbers that are less updated. So if I can just put on the record the age of cases on hand for protection matters. The numbers Mr Hawkins gave were as at the 13th of October. The actual numbers as at the 31st of October are less than 12 months, 16,919, 1 to 2 years, 11,744, 2 to 3 years, 6,092, and more than 3 years, 5,658. So, which is a much better figure than 12,929.
It is.
Well done. I thought it would be better, Mr. Crew, when you you made sure to correct the record.
Thank you,
Senator.
Thank you very kindly, and that's all the questions we have time for this evening. Okay. It means we're now in a position to be able to release you. So thanks very much. We will now take a short suspension while we welcome our next witnesses. Thank you very much. Broadcasting, and I welcome officers from the Federal Circuit and Family Court of Australia. Mr. Pringle, would you like to make an opening statement?
No, thank you. I tabled only, I think, 6 weeks ago an opening statement which is very current still. I should acknowledge, though, I'm here with Virginia Wilson, our Deputy CEO, Anne-Marie Rice, who heads up our Family Law Registrars nationally, Janet Carmichael, who heads up our Court Children's Service nationally, and Hayley Foster, who's Director of Family Violence and Access, Equity and Inclusion. Thank you, Chair.
Thank you, Mr. Pringle. We'll proceed directly to questions. Senator Scarr.
Thank you, and good to see you again, Mr. Registrar. What could you tell us in terms of how the Federal Circuit and Family Court of Australia is currently handling workload and managing the huge caseload that, given the nature of your jurisdiction, is not just large, but it's also extraordinarily important, especially in the family law case. Are there any indicators you can provide us since the last time you appeared to tell us as to whether or not the cases are being dealt with more expeditiously, or you're falling a bit behind? What KPIs can you give us an insight into?
Thank you, Senator. Generally speaking, on an average year, we'll do over 100,000 filings across all jurisdictions that we manage, with the lion's share of that being family law. Yeah. The reality is that in a number of the areas of law that we cover, the filings have gone up quite significantly in recent times. So there's been an increase in family law, but the most marked increase has been in migration. To give you an illustration of that, over the last few financial years, filings have moved from around 3,500 per annum to 4,500 per annum to last financial year 7,500 per annum. And we are currently forecasting, and this is dependent in part on what comes through from the tribunal, obviously, somewhere between 10 and 11,000 for the current financial year.
This is in relation to migration?
Just migration, yes. So it's grown from the last year by about 64%. In small claims, fair work matters, we've had a very significant growth of about 108% on previous filings as well. And so what we are experiencing, generally speaking, are more filings. In terms of dispositions, however, and finalisations, we have been clearing in those areas more than ever before. That's including due to the funding received from government, such as the migration funding. But the problem is that is at the moment not quite keeping pace with the increase in filings there.
So you had 3,500 in which year for migration?
So that was 3 financial years ago. So it went 3.5, 4.5, 7.5 last financial year, and now it's on track for between 10 and 11,000.
That's extraordinary.
It's a very significant growth.
Do you have any data with respect to the time it's now taking to resolve those matters, or the median time to deal with those cases?
In migration, the time frames are speeding up because we're dealing with them more swiftly than before. Our clearance rate is up substantially. It's now in the 80+ percentile, whereas before, about 5 financial years ago, it was more in the order of about 60%. But I'll have to take on notice and give you more detailed information of the time to finalisation there, Senator.
Okay, if you could. Do you also keep details with respect to the outcomes of the cases in terms of whether or not the appeal was upheld, or?
Yes, we can clarify the percentage that were remitted back to the tribunal or dismissed, and generally it's a very low percentage that get remitted. But I can take that on notice and give you specific figures. This is again just for migration.
Yeah. Okay. In terms of the workload in the family law space, you mentioned the family law workload has increased. Do you have any figures to give some clarity with respect to the magnitude we're talking about there?
Yes, well, we received last financial year 101,092 family law applications of different types. And so the finalisations in those areas, I'll clarify for you in a moment. So it depends, Senator, which area you're looking at, whether it's final order applications or interim applications. But the finalisations have stayed relatively steady across the last few financial years. There has been a growth in filings. If you look at both courts, we had filed 14,659 final order filings last financial year. That was a growth on 14,218 the year before. So you can see that that went up marginally, but when compared to migration, that went up substantially. And as I mentioned earlier, Fair Work, small claims matters also went up very significantly. Are there a particular area that you're interested in drilling down into?
One area which has been brought to my attention is relation to family violence related matters. Do you have any figures in relation to particularly sensitive areas where time is of the essence?
Yes, I can give you some information on that. Bear with me 1 second. Where's my rating statement? Here it is. So, family violence has, and other major risk factors have very substantially increased in recent times. If you look at how that has tracked over the last 4 years, the proportion of parenting cases that allege family violence has increased from 80% of our parenting cases to 86%. Cases alleging child abuse have increased from 70% to 77%. Cases alleging 4 or more risk factors, such as family violence, mental health issues, drug and alcohol abuse and so forth, have increased from 66% to 73%. And so generally this is a consistent trend that we're experiencing, that the cases are highly complex, multiple major risk factors are appearing in all of our parenting cases.
So how is the court managing workload between judges considering issues like dealing with some of these cases, which are extraordinarily complicated, must be quite taxing, draining on the judicial officer, notwithstanding however much training they have and experience. How are you managing those judicial workload thresholds?
There's a multifaceted approach. First were the reforms that occurred back in 2021, where a lot of the work was regraded to be dealt with by different tiers of judicial and other registrars, which has freed up judges to deal with the cases. But the cases that the judges deal with now, understandably, are very complex when they get to them. We have the Lighthouse program, together with the high-risk EVIT list, that not only identifies these high-risk cases, but also then deals with them in an intensive manner. It's doing those very efficiently, considering how complex those cases are. Most of them will resolve within 12 months. We also have our First Nations program with our Indigenous Family Liaison Officers that assist in cases with parties who identify as Aboriginal or Torres Strait Islander. That is an important area. Unfortunately, we can only cover about 47% or so of our First Nations cases. with the existing Indigenous family liaison officers, but they do an amazing job in that area. We have our Court Children's Service, who also do an amazing job, our psychologists and our social workers, who identify these risk issues and provide expert reports to the judges. And so beyond that, we have mechanisms to support our judges. The Chief Justice has an incredible wellbeing and training and support program for the judges, as we do for our registrars, which involves wellbeing support, trauma-informed practice, and vicarious trauma training, as well as various other forms of family violence training and the like. So it is very intense. It's very difficult work that the judicial officers do, and we're very proud of what they do.
And in terms of assessing whether or not the court has the resourcing it needs to deal with the caseload, including the dramatic increase in the migration caseload and the increasing complexity of a number of the family law cases that you referred to, what can you tell this committee in terms of the resources you have? Do you have enough judges? Do you have enough registrars? Can you give us any insight with respect to resourcing issues?
Well, we would always take more, always, but the reality is in recent times, to the credit of government, migration funding has received very substantial funding in 2 tranches over the last few years. As I indicated before, that has helped a lot in regard to backlog, but the spike in filings coming in the front door is still overwhelming that. So we are obviously in constant discussions with government about those needs. In family law, the complexity is the real issue, and ensuring that Lighthouse and Indigenous Family Liaison Officer funding is continued is really important going forward. Similarly, with other areas of general federal law, including Fair Work, which is continuing to grow, it is important to keep an eye on that. There's never an easy, if I can summarise it this way, there's never really an easy point at which you will reach the point where you have everybody that you need. But the efficiencies that we've managed to gain through the modernised court approach with the Chief and others have spearheaded has resulted in some pretty effective use of the existing resources, but there are certain areas that we could very much welcome some more support. We do think there are some gaps also in Lighthouse, the ability to cover regional Australia efficiently and effectively, cover property cases in the same way that we cover parenting cases, and to better support First Nations families nationally would all be part of areas that we would like to expand funding, if at all possible.
Okay, so just my last question, I just want to draw out some of those particular areas where you mentioned that increased funding would be of benefit. I was going to ask you about regional resourcing, and you referred to the Lighthouse scheme.
Yes.
Being supplemented, if I can put it that way, in regional Australia. Can you just walk through those areas where you think additional funding could assist?
Yes, well, Lighthouse is a terrific program and well funded, but it is only covering our major filing registries at this point. Yeah. It does not cover certain other registries such as Lismore and some of the smaller regional registries. It also doesn't cover our circuit locations, which are roughly 1 in every 5 of our filings. Circuit's obviously very important from a rural and regional point of view. We would like to be able to actually go out as well and go on country if possible to reach First Nations families and some of those more remote families, and that would involve some additional funding there for regional Australia. Now, we cover that as best we can electronically, but there is also somewhat of a digital divide in terms of how certain parts of communities can actually access technology. When it comes to First Nations families, we know that they screen lower than some other cohorts And so again, a focused approach there and expanding Lighthouse would be helpful. Similarly, as I mentioned earlier, property filings, that is those that are only concerning property disputes, are not covered by Lighthouse at this stage, and we think that that's a gap that could be well filled. It's important because it's very likely through economic coercion and abuse, financial abuse, that family violence is playing out in those cases that we can't cover as well as we would like to.
Okay, thank you to you and your team, Registrar. Thank you.
Thank you, Senator Scarr. Senator O'Neill.
Thank you very much, Chair. And I was very interested, and I actually was in the room and listening to the responses to Senator Scarr's questions this time, so that's quite helpful. Well, I guess good government's always here to help, and it's really wonderful to hear the impacts of investment in justice, access to justice and support for people who at a critical part of their life are engaging with a system that is often completely unknown to them and can be very, very intimidating and frightening. So, you know, when you're at near rocks but at sea, you go to the Lighthouse, and this is the project that you've just been discussing with Senator Scarr. So I haven't actually seen this in action, in addition to the funding and the categories of change that you've been talking about. Could you sort of flesh out for me what the Lighthouse project practically does for people who are engaging with the court, and how that differs from what was happening before, and then the consequences that emerge from that change?
Yes.
Thank you.
Thank you, Senator. So Lighthouse is world leading in that a purpose-built application was designed through Relationships Australia, South Australia Professor Jen McIntosh, and the courts to effectively allow parties to fill in a fairly straightforward series of questions on that app, and within around 10 minutes it identifies a risk rating effectively on a traffic light type scale, high risk being red and so forth. That allows for risk to be identified very early. And
so it's an app that allows you to triage in a way that was unable to be done before?
Well, in a confidential way, as opposed to the material that's filed on file, which can often, people will sometimes not want to disclose risk for fear of safety, and there's cultural and other reasons why they may not wish to. But this way it's a safe and confidential environment where they can actually disclose their risk. This allows then the court to know in a confidential way what the risk level is. For those high risk cases, it then makes its way to highly qualified triage counsellors. There are counsellors who receive specialist training in this area, who can then interview those individuals who are high risk and refer them off, and it's, as far as we know, the only court doing this nationally or possibly internationally, refer through the court itself, through those triage counsellors, off to support services, health and other support services. This then allows those people to receive immediate support, and quite often a high proportion of the high-risk litigants have not been receiving that support and now do. At the same time, it creates a flag for the court as to whether it should go on our high-risk list, which is known as the EVIT list. That EVIT list is specially funded with specially trained registrars and others who will deal intensively with those cases that need extra support because they're more complex in nature. So it is essentially a way in which we can deal with the complexity intensively through additional resources. It will also mean that they receive reports like child impact reports from our Court Children's Service at an earlier point in time, and ensure that they're given every opportunity for all the issues to be unpacked and dealt with effectively through this case management process. In the past, by way of contrast, there would just be the normal case management pathway. Now, obviously, the registrars and judges who were dealing with cases would do their best to pick up on all of the risk as they do now, but through the Lighthouse as a dedicated program with additional funding, highly trained people who can deal with these matters intensively throughout the case management life of a case.
You've flagged there's an app and a degree of literacy to fill in, but I notice in your response you also indicated that, regionally and in other terms, in other categories, there's a digital divide.
That's right.
So how do these funded specialists, specially trained registrars, mediate that literacy gap for those people? Do they fundamentally do that? Are they the bridge?
So the registrars are involved at a later point in the process. Okay. Early on in the process, when the app is filled out, it's designed to be at a literacy level that is around, I think, from memory, 10 years of age or thereabouts. And so it's fairly straightforward to fill in. The questions are very carefully designed to be straightforward to fill in. And that's right. And that provides, they're provided with some assistance over the phone, for example, as needed. Okay. And they receive an email as soon as they file their matter, inviting them to fill out this screen. So it happens right at the point of filing, and that's one of the big differences with Lighthouse. In the past, risk was only being identified when certain materials were filed later in a proceeding. This way, it's identified right at the front door.
So there's a preventative dimension to this.
It allows the court and everybody to be informed at a really early stage of where the risk level is. Obviously, that risk level can change in the life of a proceeding, but at least it gives a very good indication early on.
So perhaps something commences at high risk and it changes over time, hopefully to something more calm. But we do know...
It can or it can get worse.
Sorry?
It can get worse as well.
Absolutely. We do know that at the moment of separation, post-separation, is a very significant moment for the escalation. And in this very room, we took quite a bit of evidence about financial abuse and coercive behaviours that escalate at that point when there's an action initiated by predominantly women fleeing.
Yes, that's indeed right.
Abuse, yeah.
If you'd like more detail, Senator, I do have a couple of witnesses here who could add layers to what I've provided at high level. Of more information, if you would like.
Thank you. Now. Could I just ask a couple more questions with regard to the high risk category?
Yes.
You mentioned a few issues. I think drug and alcohol, mental health, family violence.
Yes, family violence, child abuse, all of those major risk factors. The vast majority of our cases have at least 4 of those in them.
And how are they treated differently? When you find a high-risk situation, is it still rest with those registrars that you were describing?
And judges as well. I mean, depending on the nature of the case, the matter can be streamed through to a judge or it will stay with judicial registrars and senior judicial registrars who can deal with the cases on an interim basis quite quickly. But these are, through the screening process, I should note, 61% of matters that screen are screening high risk at the moment. So that's in accordance with some of the other data that I was mentioning before, which is coming through a different process, a notice of risk that has to be filed by the parties. But it's all very complex matters. The easier matters, the amicable matters, all of those tend to resolve before they get to court. We tend to have only complex matters in the court now.
So just in terms of cultural safety for First Nations people in particular, could you give me a sense of what I understand is Indigenous family liaison officers that are assigned at different points, how that is similar to or different from what you've just been talking with me about, and how do they work with First Nations families, and what's the court observations of having families, First Nations families, engaged or disengaged from this Lighthouse project?
Yes, thank you. We call them IFLOs for short, but the Indigenous Family Liaison Officers do an amazing job. We currently have 14. They are funded under the National Plan to protect women and children, as is Lighthouse. But they're separate from the Lighthouse program formally. Their job is predominantly twofold. One is to support First Nations parties and children through our case management process. That might be helping to refer them to all sorts of support services that they might need. That will be explaining certain things that need proper explanation. Obviously, being an Indigenous person and engaging with parties who identify as First Nations is important, because there is a lack of trust in entering our court system. First Nations families have for a very long time had good reason not to trust these sorts of institutions and structures, and so having somebody who is from a First Nations background to speak to and to have explained various aspects of our court process is really, really important for them to feel like they can trust the process. It is important that this engagement happens. There's often a misunderstanding in communities that our courts, our family courts, are part of the criminal justice system. When they understand that we're not, they can bring their dispute to us, resolve hopefully through a mediation process, which takes account of the complex family structures that might be at play, and allow and increase the chances of the child being kept within community rather than it playing out in the criminal justice system and interventions taking place. So it is a really positive system, but part of the role of the Indigenous Family Liaison Officers to build trust in that system and to support the person through the process. That includes community engagement, going out, speaking to the community, key stakeholders, Aboriginal and Torres Strait Islander groups, and elders, of course, so that that trust builds over time.
Thank you very much, Mr Pringle. Thank you, Chair.
Thank you, Senator O'Neill. Senator Shoebridge.
Thanks, Chair, and good to see you, Registrar.
Thank you.
And your team. You would have seen the reporting over the last few days about concerns about transcripts.
Yes, Senator.
I'm going to ask you a series of questions about that, but I know you didn't seek the opportunity to do an opening statement. Is there anything you'd like to put on the record to address the concerns about transcripts before I start taking you through the questions?
It's not a formal opening statement, but I think it might be helpful if I clarify a few matters.
So I'm giving you the opportunity before we jump into questions.
Thank you, Senator. I'm happy to do that. I think in terms of the construct of how transcripts are dealt with in our courts, and I can only speak, of course, for the Federal Circuit and Family Court, Division 1 and Division 2. Note our colleagues in the Federal Court were released earlier. It should be noted, most of this is actually managed through shared services structures. So corporate services, which is managed through the Federal Court entity, actually goes to tender on these, does the procurement on these contracts. We're very peripherally involved. Then once the contract's entered into, registry services, which is another shared service structure, deals with the quality and assurance aspects of how that contract is going. So for those reasons, the things that I'll mention to you are necessarily either concerning our courts or very high level, but there are some matters that you may wish later on to put as questions on notice to the Federal Court entity. Broadly speaking, it is not new that courts have been using a service provider to provide transcript services. That's something that's been, I believe, has started from the early 90s in one form or another, around 1992. Previously it was Spark and Canon, then Auscript, and now VIQ, including, of course, one swallowing up the other over time as there's been mergers that seem to have happened. In terms of the industry itself, there seems to be very significant disruption going on, which could be part of the issues which I'm about to raise in a moment. But obviously, with technology going where it is, I suspect that is causing a significant disruptor effect for some of these providers. The current contract, as I understand it, was done through an open tender process as required by Commonwealth procurement rules. And we must go through that process because ever since this whole process was privatised back in the early 90s, we're not funded for some sort of in-house system. So we have to go to a service provider, or the entity needs to do that. In terms of the issues that were raised in the article, Senator, I must say I actually concur with a number of them. Some I would speak about separately in a moment. But I can speak on behalf of at least our two courts that in recent times we've been very concerned and not happy with the level of service of provision by the contractor. There's been really significant delays at times, which I understand have been caused by a shortfall in staff, which is being addressed, but it has caused some concerns, including...
Registrar, can you give an indication of how long those delays have been?
It's hard to say, Senator. I wouldn't be able to say specifically, but I know that a number of judges were concerned about the fact that their transcripts weren't delivered on time, so they, for example, had to adjourn off hearings where they might be delivering a judgment, those sorts of things. That causes disruptions not just to the court, but obviously the parties, which is never desirable. There's also been levels of errors that would have been that are concerning at the level that have been coming through during that period of delays and difficulties, and also some audio problems where audio isn't on at the times that it should be on, and there are gaps in some parts of the hearings. I know that our colleagues in what we call court and tribunal services or registry services, which is a shared structure I mentioned earlier about quality assurance, have been working really hard with the provider to turn that around, because they were clearly short-staffed, the provider, and they put a lot of pressure on them to fix that. And since then, the backlog of transcripts and the delays that have been happening have lessened considerably. So I'm grateful to them for the hard work that they've done. But the reality is it hasn't been at the standard it should have been. The second area that I would agree with the concerns that have been raised, Senator, is in terms of access to justice. These systems, and given that it was all developed back in the early 90s, are really from a time when complex proceedings and parties paying for transcripts there would effectively fund this. But when you look at courts such as ours, we have 84% of our migration applicants being unrepresented, and of course have huge language barriers. Many people also in our family law jurisdiction and in bankruptcy and fair work. And a system where parties have to pay this amount is not one that's amenable to parties who have those sorts of disadvantages. It helps, it's sufficient for parties who have the means, obviously, but not necessarily for others. I think in this day and age, with technology heading where it is, it's getting more and more accurate all the time. The very near future will necessarily involve much more accessibility to transcript and hopefully to audio as well through technological advancement. But it's not quite there as we understand it at the moment in terms of accuracy. We are actively looking at that though, and our aim will be to try and make sure that the next contract that is entered into, or the new structure that the courts end up settling on, is one that has a much higher level of access to justice than what we have at the moment in terms of access to transcript and audio. So they're the main issues that I wanted to note. In terms of the allegations, the access to transcripts, there was some slightly inaccurate things that were mentioned in the reports. Technically, a transcript can be obtained not necessarily through a judge's order. A registry manager can allow for access to audio in certain circumstances. Now, those aren't codified, I appreciate, but one can appreciate that if all of the audio was made available to all parties all of the time, then obviously the transcript provider would have a problem with that because nobody would pay for a transcript. So it has to be done carefully, but also there are safety issues. If you look at our family law proceedings, for example, and section 114Q, which protects the anonymity of parties in family law proceedings, it would be, one has to be careful how access to those is done by non-parties. By actual parties, different story, I appreciate. The transcript contract also has privacy and security requirements which are consistent with the Commonwealth Security Statement of Requirements. So those issues to do with is the information secure are, as I understand it at least, broadly dealt with in the contracts themselves. I can't speak to whether they are in fact secure in the way that you were raising earlier. That's a technical issue that would have to be taken on notice by the Federal Court entity IT team.
Thank you. Thank you for giving that background. It's actually very useful, Registrar. Can I ask you, in terms of the privacy protections,
yes,
are you able on notice to provide the contractual provisions that provide the privacy protections? And to the extent that you're aware of where the data is held, I assume it's digital recordings, is that held by VIQ in Australia, on Australian servers? Is it held overseas? What's the data protection like in practice?
Senator, I'd have to refer that question on notice to, in fact, the Federal Court of Australia entity, because they run all IT services across not just our two courts, but the Federal Court and the Native Title Tribunal, and they would be able to answer those.
If you could take it on notice to the extent you can provide that answer, and I'll also put the question on notice to the Federal Court entity. When does the contract expire with VIQ Solutions? And are there termination provisions where there have been repeated breaches?
I understand the current contract expires in June of next year, but there are renewal options which the entity is considering in consultation with the courts. I'm not sure, you mentioned earlier, if I can clarify certain provisions, including privacy provisions, Senator, I have to take on notice what provisions are commercial in confidence. I do not know the answer to that because we don't manage the contract.
Registrar, I'm comfortable for you to take it on notice, and obviously you don't have them here, so you have to take it on notice anyhow, and
yes,
you can assess those matters on notice. Is it true that the costs of court transcripts range from about $3,000 to $5,000 a day? Are they the kind of fees that litigants
depends
pay?
for a full day's trial and how quickly the parties want the information. So if there's a higher charge, if you ask for it same day, for example, as opposed to a 10-day lag, so it can vary quite markedly depending on that.
Have you got the cost schedules that you can provide?
The contract does have cost schedules in it, but again, I'll have to take on notice whether those are able to be disclosed.
Well, I assume they do get disclosed when people are told how much they have to pay for a transcript.
Yes, they effectively get, I think, a quote of how much it will cost them for the particular request, but the schedules themselves are part of the contract, and I'd have to take that on notice. I'm sorry.
What I'm putting to you is when they charge people, they're telling people how much their services cost. That there can't be a reasonable commercial in confidence argument for the provision of a service in relation to a public court. But anyhow, you can take it on notice.
Again,
it seems hard to see how that could be commercial.
Senator, but I'm happy to take that on notice.
Can I ask you about the concerns about the other concerns were about the conduct of judicial members?
Yes.
What do you understand is the discretion that judges have to edit transcripts, and what do you understand to be the oversight of decisions made by judges to edit transcripts?
Yes, Senator, I must say I was surprised about the matters raised in the article in the way that they were. And the reason for that is that our courts, but also, in fact, all Commonwealth and state and territory courts, as I understand it, are part of a guide to judicial conduct, which has been agreed through the Council of Chief Justices. And I'm happy to refer that to you now. It's under the AIJA, the Australian Institute of Judicial Administration. The Guide to Judicial Conduct states this, and our judges have therefore effectively signed on to this, and as we understand it, would faithfully follow that. A judge may not alter the substance of reasons for decision given orally. That is the basic principle. Subject to that, a judge may revise the oral reasons for judgment where, because of a slip, the reasons, as expressed, do not reflect what the judge meant to say, or where there is some infelicity of expression. Errors of grammar or syntax may be corrected, references to cases may be added, and may be citations for cases referred to in the transcript.
Mr. Spring, I think we're all, well,
so the judges take that seriously, Senator, and it is a very serious allegation to make of our judges that they would operate outside that sort of framework.
The slip rule relates to judgments and reasons for decision that are given. For my sins, I worked for about 2.5 years in the Parramatta Registry of the Family Court for a judge that did multiple extempore decisions, and I know how the slip rule operates. But we're not talking only about clarification of reasons for decision. The concerns that have been raised go to editing of transcripts in the course of trials being run, comments made by judges in the course of examining witnesses, go well outside just the standard slip rule provision for clarifying or correcting or extempore judgments. Is direction given to judges about that, those matters?
Well, I think the passage that I should read out to you is the direction. They've got a very.
That's only about reasons for decision, Registrar.
Yes.
Well, of course, judges
given orally.
Yes, but the concerns that have been raised in the ABC reporting go well beyond reasons for decisions. It's about conduct of judges in the course of trials.
Yes,
comments they make, well outside of reasons for decision. What oversight is there of judges editing out of those issues in the transcript, and what rules are there?
Well, these are judges, Senator, who deal with tens of thousands of cases a year. It would be, I would think, administratively almost impossible to check every single process that you've just alluded to. But I think there's something worth clarifying here, and that is that VIQ, when it provides a transcript, and if a party has asked for a transcript, that's provided directly to the party. We get a complimentary copy. So whatever changes might happen would, if any would happen, like an error of a name or something like that, would happen as between VIQ and the party. I'm not sure that it's quite understood that if a party pays for a transcript or seeks a transcript, VIQ provides it directly. There's no intercept from the court in that circumstance.
And so when family law barrister Brian Kelly said there have been times when I've reviewed transcripts I've ordered and found they didn't line up with my recollection of my notes. During an interim hearing some time ago, the judge made comments that I felt demonstrated an error. I found the relevant section of the transcript I required to base on the appeal was missing. Those kinds of issues?
Well, again, to take that comment and extrapolate that that's what normally happens, I'm not aware...
I didn't say it was normally happening.
No, but what I'm saying, Senator, is I'm not aware of a circumstance in which a specific complaint has been made of that nature to the court saying, here's the transcript, here's the audio we obtained, this is the difference, for example.
Mr Kelly says he decided not to make a formal complaint to the court or the Attorney-General, and colleagues who experienced similar issues told him that they were hesitant to make formal complaint because of retribution. Colleagues have told me they've been aware of transcripts that haven't lined up with what they thought was in there or what their notes have said, and they haven't made any complaints either because you have to worry about the repercussions on your client and also on the lawyers themselves. I'm asking you what directions are given to judges about what they can and can't do in relation to amendments to transcript. The only point that you've raised is in relation to decisions. If judges are getting broader is there any other space in which judges can edit transcripts apart from reasons for decision?
I think the slip rule would apply where the slip rule applies, Senator. But ultimately, what this comes down to is whether judges are being carefully trained and guided, and they are under what the Chief Justice does. They receive very intensive induction processes. They get training. They've got bench books. They've got conduct processes and policies. I'm very confident that the judges are following the proper processes here. If there are specific allegations or specific complaints of the nature put, certainly there are complaints processes that can be undertaken presently for that.
Well, perhaps you can provide on notice what the complaint processes are, because I don't blame you for there not being a judicial commission, but there is no federal judicial commission. So if you could provide that on notice.
Happy to.
Your court's website says that recordings are, and I have a quote here from the transcript, only available in exceptional circumstances. That's what your website says. At least last time I checked it was.
Yes.
Is that what the website says?
It does in regard to audio, correct.
Yeah. Now, of course, a large amount of these concerns about the accuracy of the transcript could be fairly simply resolved by giving the litigants and their lawyers ready access to the transcript, even if not in every case, but in any case where they raise a legitimate concern about the accuracy of the transcript, which would be a much lower threshold than exceptional circumstances. Yes. Who sets the exceptional circumstances threshold?
There isn't a prescribed threshold. The registry manager deals with the matter as the website clarifies on a case-by-case basis. I've certainly come across circumstances where I know parties have been given the audio because they then have raised some concern about a judicial officer's process in a complaints process, for example. That has happened before. So it certainly does happen, but I don't have the data to tell you exactly how many because it's dealt with through the shared services structure.
My final question.
You said that before. We've got 5 minutes left with...
Okay. Will you...
If you can on notice...
Yeah. Well, will you on notice provide any advice to this committee about whether or not the court is intending to clarify on their website and to litigants and lawyers the circumstances in which they can get access to a transcript?
I'll certainly take that on notice,
to a recording.
Senator. Thank you. And
thank you very much, Mr. Pringle. Thank you, Senator Shoebridge. You now are released by the committee. Thank you very much for your time this evening. We are now moving to the Office of the Commonwealth Director of Public Prosecutions. And while we are doing that, I will let the Australian Law Reform Commission know that we will not get to you tonight and you will be released. Apologies to the Commission.
Office of the Commonwealth Ombudsman.
Australian Law Reform Commission is who we are releasing.
Good.
The other two on the program have already been released.
Gotcha.
$10:30. Now, noting that we don't have a lot of time left before our hard marker of a 10:30 finish, I welcome officers from the Office of the Commonwealth Director of Public Prosecutions. If you've got an opening statement, I would request that you table it.
I don't have an opening statement.
Thank you very kindly. We'll proceed to questions and go to Senator Scarr.
Thank you very much. And Ms Sharp, good to see you. I want to ask some questions in relation to the matter of Crown and Clark, number 9. I've had a quick look at the judgment. There were scathing comments in relation to the matter. Most of them directed at the ATO, but there was discussion in the judgment with respect to a number of applications or approaches that were made to the CDPP as to whether or not there was any case to answer. ultimately it appears a decision was made by the CDPP not to proceed with the case. Can I ask you, given what the judge found, what internal review is the CDPP undertaking with respect to the management of the case, and what lessons can be learned from the perspective of the CDPP?
Thank you, Senator, for your question. The case dealt with two different charges, and one of the charges was not proceeded with, as you've outlined. In terms of the process when we receive a judgment like this, and I think as has been noted earlier in evidence today, we're appealing the decision, so I won't go into the detail of particular findings in this matter. I think it would be inappropriate given that we have appealed. We review findings when they come in. We take all judicial observations of our work seriously, and then we'll discuss them internally in one of our forums in terms of whether there are any lessons to be learned and any changes that need to be made. Any changes that need to be made.
Do you sometimes seek advice outside of the CDPP to review the management of a case, potentially from a former director or from someone else who's got extensive experience in the criminal law jurisdiction, to give you an independent view with respect to how a case has been managed?
We have a process of reviews, and that process does include the option to get external advice or have an external review of the way a case has been run. Yes.
Okay. And how do you become alerted to judicial comments of this nature? What's the internal procedure?
We have a number of different processes. When any appeal is handed down, team members will prepare a summary of that, and that's shared with the executive committee of the office when the appeal is handed down.
So this wasn't an appeal?
For significant matters like this. The matters are reported up through the team, but I meet weekly with my staff, and so significant matters can be discussed in that. We have other fora where we discuss cases internally, but the way the office is structured is like any law firm where the teams have a team leader and significant matters are reported up the line.
And then in relation to matters like this, what communication protocols do you have in terms of alerting, say, ministers who might be reasonably expected to be asked about the case, alerting the Secretary of the Attorney General's Department? What other protocols do you have?
Well, in terms of a case like this where the ATO was involved, they're obviously aware of the decision when it was handed down, and various members of my team have been engaging with the ATO throughout the process since the decision was handed down. My office is not subject to legal services direction, which is a reflection or a measure taken to ensure the independence of the decisions that are made when the prosecutorial discretion is exercised. But from time to time, when there are cases that need to be discussed, I do engage with the department about it.
Okay.
Thank you, Ms Sharp. We have reached the hard marker of 10:30. Apologies from myself and the committee that we didn't have more time to ask you questions this evening. But thank you very much for your patience and for appearing before the committee this evening. That concludes today's proceedings. I thank the ministers and departmental officers for their attendance, as well as Hansard Broadcasting and the Secretariat for their assistance.
It was a useful 5 minutes.
Can I ask a committee member to move acceptance of documents tabled throughout today? Thank you very much. I also remind senators that written questions on notice should be lodged with the Secretariat by 5 p.m. Thursday, the 11th of December 2025. The hearing is adjourned.